Good afternoon, good afternoon, good afternoon, amazing law nerd. It's so good to see you. It feels like it's been a minute, even though it hasn't, but with travel last week, things are things. But today we're back in court in Utah for the hearing of Taylor Frankie Paul versus Dakota Mortensen and Dakota Mortensen versus Taylor Frankie Paul, because both of them are in a hearing for restraining orders, protective orders against the other. So there are dual and competing protective orders because both have filed for a protective order against the other, so both of them are asking for a protective order against the other. If you are not familiar with their names, don't worry. We will do a really quick road so far, then we'll fly to Utah, then we will go to court. We are going to be dealing with, again, a protective order hearing. We don't watch a lot of them on the channel, but if you have not seen a protective order hearing before, both parties are going to be making allegations of domestic violence against the other party. We are going to see a lot of that. So that's what we are going to see today. For those of you that are familiar with the parties, a lot of you are probably going to sit there and be like, wait, nuh-uh. I know. It's deep breaths. We're going to see what the lawyers have to say, and I am sure they're going to have a lot to say. So if you have no idea who's in court today, don't worry, I got you. If you do know who's in court today, deep breath, I got you. It's going to be okay. It's going to be okay. It's going to be frustrating, but it's going to be okay. So we're going to roll the intro. We're going to do a very brief road so far. We're going to go to court in Utah. It's a very late in the day hearing for Utah, but hey, here we go. So we get to be in court together. They started in court not all that long ago, so we've got a bit of Zoom room, and we're probably going to wish we're going to be glad we had it. I'm always glad we have Zoom room. I've never regretted having Zoom room, not once ever. Sometimes I've wished that we've had more, for sure, but I've never regretted Zoom room. Also, if you find yourself unable to chat, don't hesitate to subscribe, because we keep our chat on subscribers mode, because subscribers get to see the little rules about being a law nerd. And when we are dealing with difficult cases that are polarizing on the internet, sometimes people forget the law nerd rules. So we just set it to subscriber mode so they can go, oh, there's rules. Yes, on this side of the internet, there's rules. We are going to see what the parties are arguing in court and see what the court does. That's what we're here to see. What are the parties arguing in court? What is the court going to do? My feelings about this case are everybody needs to stay away from each other. That would be best. For a while, everybody just separate sides of the state of Utah, and that will be best for everyone. So are we ready? All right, let's roll the intro and let's get to court. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right. So for those of you who are like, Emily, what is the TLDR, the road so far, the what is even happening with this case? I got you. Taylor Frankie Paul, you may know from Secret Lives of Mormon Wives, or you may know because you heard that she was the Bachelorette and then the Bachelorette got canceled. So you might be familiar with her that way. Dakota Mortensen is the father of her youngest child. They have one child together. She has other She has other children from a prior marriage. On the heels of that prior marriage, as she was getting divorced, she met Dakota. They started dating. One instance of domestic violence between the parties happened as they were early days dating. Dakota didn't call law enforcement. The neighbors did. Taylor was prosecuted for that, is still on probation for that. These instances are not going to be a probation violation on that. We covered that in other content. So she and Dakota have had a history of having DV-related incidents between them. She is still on probation for that incident. Right before The Bachelorette went to air, the video of that prior incident that she had already been prosecuted for found its way to TMZ via the owner of the video, which is the person who took it, which is Dakota, that happened to be on their child's birthday. The TMZ aired it to the entire world. This is before she was pregnant with their mutual child. So that video that you might have seen on the internet is from that prior incident. What is going on today is incidents that have happened since then. Some of those incidents happened before the two of them had a child custody agreement. She had 70%. He was the other portion of that. That was their child custody agreement. Yes, 30. Then there was another incident that happened between them in the overnight hours, late February 2026, prior to this video coming to light, though the video that came to light is from 3 years ago. I know. So there is an incident between them in 2026. The prosecutors have decided not to prosecute anybody in that situation. No one's getting prosecuted. So they are in court because the day that the video went to TMZ, Dakota also filed a restraining order against Taylor. They still have a child custody case against each other in court. The last court date, April 7th, Taylor filed a restraining order against Dakota, and now they are back in court for the hearing on the protective orders. I will use protective order and restraining order interchangeably. They are not synonymous in Utah. One deals with criminal cases, one deals with civil cases. This is a civil restraining order, not connected to a criminal case. I will use them synonymously because my brain defaults to using them synonymously. Just know that there is a technical legal difference. This is a protective order hearing, so we are accurate. Would I love my brain to not default to restraining order? Sure. Is that going to happen? No. So both of them have filed for protection against the other. They still have a child custody battle between each other. Part of what's stalling that child custody battle is Dakota's legal team waiting for information about Taylor's finances. That's part of what's stalling the child custody part of this. So now we are in the protective order part of this that is going to impact the child custody hearing. You will see that there will be a guardian ad litem who is a lawyer that represents the interest of the child. Not mom, not dad, child. And so we will likely hear from the guardian ad litem, sometimes GAL, today as well. My opinion on the situation, not that it matters for much, but my opinion on the situation is everybody needs to stay away from each other for a while. Like a while. And they need a third party to exchange custody of the kiddo. Kiddo is young. 2, 3, young. Toddler kiddo. They need to stay away from each other. So today what you are going to hear is a lot of, they did this. That's what we're going to hear. Also, I have long questioned why, when the criminal case happened, there was no stay away from each other. Because when the criminal case happened with Taylor Frankie Paul as the defendant and Dakota as the victim in that case, there was no stay away order, which is very, very, very unusual in a domestic violence case. This is my supposition, is that it was because they were still filming together. And their money is connected to each other. And both of them said, we don't need a protective order. But now things have shifted. And we are now seeing what's happening with the shift. And, excuse me, some of you have asked, Emily, you said Dakota gave the video to TMZ? Yes. And I will continue to say it. Why? Everything we have learned about TMZ owned that video. They watermarked that video. They owned that video, which means they had to get it from the copyright holder, which means the copyright holder is Dakota. Even if somebody else sent the email with the link to the video, he still had to release the rights of it to TMZ. Dakota. That's where it came from. So, this court hearing is going to be a lot of this side did this. And you are going to sit there and be like, but Emily, the truth is probably somewhere in the middle. This is family court. Every lawyer is there to advocate for their client. And that means that the lawyers are going to be arguing the facts in the light most favorable to their client and least favorable to the other side. So I understand that there will be disagreements, I will have disagreements. I'm going to wait to hear from the guardian ad litem because that's generally the middle. So, as we go into court, it is going to be, I imagine, a contentious hearing, as these things are. If you do not know these parties, that is perfectly fine. You will watch what these hearings look like when both parties are alleging things against the other party, knowing that there are no criminal charges coming from any of this. If you know who these parties are and have watched this play out across social media and Secret Lives of Mormon Wives and the rest of it, you are probably going to watch here and be like, that's not how I see all of this going down. Totally fair. But it's going to be, well, a lot of, they did this. And I imagine what is going to come out at this hearing is going to be unflattering to everyone. Because earlier this week, Taylor Frankie Paul asked to have this hearing sealed. Asked to have the records sealed, and a lot of the records are sealed. Asked to have the records sealed, asked to have the hearing sealed, and the court denied it. So this hearing is going forth publicly because the court denied the hearing being sealed. If you have never experienced family court, I'm very glad for you. If you have experienced family court, there will always be replay on this with timestamps if you need to bounce and come back, because I get it. So we are going to fly to Utah. We're going to go to court. Deep breath, everybody. We don't do a ton of these cases. They are difficult. I do think it's an important part of our legal system that we don't often cover. And so today we are going to do that together. You ready? All right, law nerds. No, wrong one. And I've been needing to replace it. I know. We were good. Damn it. I know. It's been a business. The back is still bugging. The liar hasn't gotten replaced yet. It will though. Today we're just deep breaths and gavels. All right, you ready to go to Utah, law nerds? Let's go to Utah. Look, I remembered to say we were in a hearing. Look at us. Look at us, everybody. We're ready to go. We're ready to go. I think that the parties will be in court. I saw a question about my jacket. It's the style of the jacket. It is meant to look inside out, but it is
we are calling two matters simultaneously.
It is the style.
The matter of Dakota Mortensen and Taylor Frankie Paul.
Let's see if I can turn this up a little.
264901444, and the matter of Taylor Frankie Paul and Dakota Mortensen. Case number.
All right, I'm going to have to try to gain this up a little bit for you guys.
Council appearances, please.
I'm going to grab our closed captioning.
On behalf of Dakota Mortensen.
I don't know where they are.
Both petitioner and respondent.
Hiding somewhere.
Okay.
Good afternoon, Your Honor. Eric Swinard and Brian Ficklin for Taylor Frankie Paul, who's present with us as well.
Okay. Yes.
My name is Guardian ad litem for the minor child.
We'll have one attorney each making an oral argument. Is that right?
Yes, Your Honor.
All right. Very good.
Okay.
All right. So
the court asked because multiple attorneys introduced themselves, and the court was like, one horse, one rider. Or you can't ride two horses with one ass. No, other way. Either way, one horse, one rider. The court's like, do not tell me we are doing more. We are not doing any more. One lawyer. Different lawyer for Dakota than we saw in the last hearing.
at the last hearing, I had expressed some hope that there might be some resolution to these matters. Were there any efforts made in that regard?
I don't know if I'd call it efforts fully, Your Honor, but I mean, we've definitely contemplated where we're at, and we've had some good discussions about the current parent time schedules. So,
Okay, any resolution on anything?
Nope.
I don't believe so, Your Honor.
All right.
And you can see that Taylor Frankie Paul's in court with her lawyer. Dakota is in court with his lawyer.
The first matter was the one that was filed by Dakota, so we'll go ahead and hear from you, Mr. Hall, first.
Thank you.
Now, we have an option here, chat, that we're going to have to discuss together because we have two options. We have the in-court camera, and we have the option for the multi-screen because we're also recording it, which took me a little bit to sort things out technologically. But we also have the option to use the layout for the WebEx, where you can see the parties sitting at council table, but it's the 4 squares. So if we want to do the multi-angle on the WebEx, we can. Let me, which, you guys are like, WebEx. Okay, perfect. We'll switch it. We'll switch it right now. All right, perfect. A lot of you are like 4 screens. Perfect. Because we'll see the judge, but we won't see the back of the lawyer's head. We'll see it. Hopefully the WebEx has better audio. One would hope. But if we hate it, we can always switch back. I mean, we'll be.
That was the first inkling because you realize.
That actually sounds better. Did that sound better to y'all? Let me rewind this a little bit because it did sound a lot better. And then we will go from there. All right. So let's grab, I'm going to have to move things around a little bit. And then we will probably switch WebEx feeds. I had a little audio trouble at the very beginning of my WebEx feed. And then I'll switch feeds. Let's make sure I can get out of the way enough and we'll go from there. All right. Let's see. I'm going to have to move me down here. And then let me move the WebEx feed just a little bit and see how we do. And then I'll switch feeds in a few. Let's see. We can do that. We can kind of move it that way a little bit. That's better. And then we will switch in a few minutes when we catch up because mine had a little bit of sound at the difficulty at the beginning. All right. We happy with this feed? Better? All right, let's go. Hopefully this is better audio.
There
we go.
Matter of Dakota Mortensen
That is
and
so much better.
Taylor Frankie Paul, case number 264901444, and the matter of Taylor Frankie Paul and Dakota Mortensen, case number 264901819. Council appearances, please.
Brent Hall on behalf of Dakota Mortensen, who is present, both petitioner and respondent, but yes.
Okay, we've got, this is Taylor Frankie Paul in the like white and or cream and or whatever neutral color dress. This is Dakota in like a bluish suit and tie. Both Taylor and Dakota, let me move me a little bit. Both Taylor and Dakota are sitting in between their lawyers. Is it weird if I'm just floating up here for a bit? Let's see if it's weird. If it's weird, I'll move.
Okay. Good afternoon, Your Honor. Eric Sweenard and Brian Ficklin for Taylor Frankie Paul, who's present with us as well.
Okay, well, oh, yes.
Mike McDonald, Garden Ad Litem for the minor child.
We'll have one attorney each make an oral argument. Is that right?
Yes, Your Honor.
The
All right,
guardian
very
ad
good.
litem is sitting
All
over
right,
here
so
where my
at the
hearing
last
bug
hearing,
is.
I had expressed some hope that there might be some resolution to these matters. Were there any efforts made in that regard?
Move.
I don't know if I'd call it efforts fully, Your Honor, but
All right, we'll
we've
move
definitely
closed captioning
contemplated where
down
we're
there.
at. And we've had some good discussions about the current parent time schedules. So
Okay, any resolution on anything?
We'll move me up here.
I don't believe so, Your Honor.
All right, well, the first matter was the one that was filed by Dakota, so we'll go ahead and hear from you, Mr. Hall,
Nope,
first.
I can't read the closed captioning down there. Hold on, we're gonna reposition things one last time before we move again.
Record's good? Good. Well, Your Honor, today we have 2 competing protective orders. One from Ms.
This is Dakota's lawyer. This is a great question. He gives beauty for ashes, says, is her first name Taylor Frankie or is her last name Frankie Paul? I have no idea. Honestly, I have no idea. It's a great question. I don't know. Chat, you can let us know. I don't know. Truly, I've never looked into it. It's a great question. Great question.
Mr. Mortensen and one from Ms. Paul. I'll start with handling our protective order first, and then I'll also respond to theirs to hopefully save time and judicial efficiency.
We'll give rebuttal to both parties.
Thank you. I appreciate that, Your Honor. I was going to ask. So first off, let's go ahead and start with the
No.
protective order.
I hate this.
All right. So
What just happened?
Mr. Mortensen filed his protective order. As you know, Your Honor, in the state of Utah, we have a few definitions for how a protective order should enter. We have to have a finding by preponderance of the evidence of either abuse or domestic violence that has been committed. Also, I will cite Patoli versus Marksbury, which is the case that indicates that the fear component is a component, but it's not required. It's neither or, as the court's well aware. In this case, actually,
we're gonna
it's,
get rid of that real
I believe,
quick.
rather simple, Your Honor.
I have no idea what's
As the
happening.
guardian ad litem has previously filed, we have an aggravated assault charge and plea of guilty by Ms. Paul.
Hold on.
Against my client. That's domestic
We'll fix
violence
it.
as specified exactly by the code, as it's one of the underlying sections. Aggravated assault under 765103 is domestic violence.
This is the 2023 incident.
This is the 2023 incident. And I would need at this point to cite the statute, Your Honor, which is 78B-7-608, that the court cannot deny a protective order solely based on a lapse of time. That being said, we've provided other evidence as well, Your Honor, of this cycle continuing. If you turn to our exhibits, we've presented at this point 9 exhibits, of one being the actual incident and others being additional incidents
Yeah,
that
I
have
have no
occurred
idea what
since the
happened.
2023.
We'll switch.
I did have
seats
one
in just a
rebuttal
second.
exhibit, but I'll get to that later, of a little previous to 2023, the February incident, but I don't need to address that
It
now.
is a very small court.
As you can see, Exhibit 1 is the actual recording of that incident that resulted in the charges. Then we have Exhibit 2, which is an incident that occurred, and the video we provided shows Ms. Paul striking Ms.
I viewed them both. I viewed them.
Oh, you viewed them all. I just wanted to run them through for the sake of the record. And then Exhibit 3, of course, was a picture of abrasions on an assault that he claimed occurred on that day, and he would testify to the same. I'd proffer. One thing I wanted to point out about that, Your Honor, is that was August 3rd, 2023. That was the day she pled guilty to the assault.
I don't have
Under
no
a plea in
idea.
abeyance. So I think that's interesting that we still had an incident that night. Exhibit 4, again, more scratches of a separate incident. Exhibit 5, again, and this is an audio recording because my client's recording device was in his pocket, not showing. It does show at least a strike of some sort on the door, which, you know, is a form of domestic violence if it breaks, but also you can hear kind of the anger in what we have there. Exhibit 6, we have an audio and video recording of, again, another assault that happened on October 15th, 2024. Exhibit 7, we have an injury that occurred. You can see the injured his nose. This is the one we had to fix, I believe, Your Honor, on the date.
I'm
This was
looking
2023.
for when our feed
Exhibit 8, we have
fixes.
another video and audio recording of the May 27th incident. So this is the one that we've been kind of back and forth with the pleadings, as you can tell. I'll get into that a little more when I respond to that, since that seems to be the main issue that Ms. Paul has in terms of alleging violence with him. Then we have the October 16th, 2025 incident that we also recorded. Oh, this is the one where he had his phone in his pocket. And then we also presented, of course,
These are incidents that Dakota is alleging. Some that they are saying are recorded, some that are not.
Exhibit 11, which unfortunately there was no recordings of the most recent incident. We're going to call it the February 22nd to 23rd incident because there's
This is the incident that Taylor Frankie Paul's lawyer called the truck tussle. That's the one they're talking about now, the truck tussle.
actually 2 events that happened, both separate on those times. This is the most recent, 2026.
Are the pictures that she provided for bruising from a different date?
Yes, my understanding is that was from the May 2025 incident.
Okay.
That's the one that I think is the greatest dispute.
Okay.
Yes, for all of you
So
who are like, wow, these
from
two
that,
don't get along, yes.
I did want to show you Exhibit 11, Your Honor. I know you've listened to it, but that's the recording of a phone call that occurred between Ms. Paul and Mr. Mortensen
When?
about a day or 2 after the most recent incident in February.
Is this the one where it was, it was represented she was screaming on the phone? Is this?
There was some screaming, yes, but what was really important was the statements that were made by Ms. Paul during that.
Okay.
Okay.
For example, at the second, just to help the court when you're looking at it, on timestamp number 2, my client asked, well, you know, why did you attack me? And second 8, Ms. Paul responds, I already told them that. And them, if you listen to the context, was CPS at the time, Child Protective Services. I already told them that, yes. Or yeah, was actually the appropriate quote. But here's where I wanted to really get into. And that was later on, about a minute later in the call, he says, well, I've got to tell the truth. And the response was that it will ruin your life, is what she told him. And then at 1 minute and 52 seconds in, you are never working again. And so that's.
So this is Dakota's lawyer saying that he has recorded a call between, or Dakota has recorded a call between him and Taylor, and they've provided that to the court. And in the call, he is saying, I have to tell the truth. And Taylor's saying, it'll ruin your life. And you'll never work again.
Why, Your Honor, I wanted to explain to the court why my client has multiple incidents of this, continues the cycle. And as you can see from the text message and other things we've submitted.
How are those statements pertinent to his request for a protective order?
Because they show.
Because, Your Honor, this is also about talking to about the other side. So that's why.
Really, it's just a first step to show the court why, as you might be wondering, why has he put up with this? Why has he waited so long to do anything? The answer is he was afraid of the force that would happen against him. That's why. If the court doesn't think that's relevant, I'm happy to skip it. But I thought that might be the first question of why did this take.
I don't know if the court's going to ask the question of why did you stay so long, because I think the court is well aware that abusive relationships are dynamic. I don't imagine the first thing the court would ask is, if you're afraid, why did you stay? I don't see that being a question, because I think how intertwined these two parties are is pretty obvious. But there has to be fear, and the court laid that out at the beginning, is that there has to be fear. So I think the lawyer is starting to argue that it goes to that to show that the fear is beyond physical, and goes to financial and working, et cetera.
So long. Why did he wait from 2023 until now? And the incident is because, I mean, unfortunately, and I don't get to say this very often with male victims, but he's a domestic violence victim, Your Honor. He is coerced either through romantic interest or interest involving
Counsel, okay.
His son, and with very charismatic texts and very charismatic personality to come back and rejoin this romantic relationship until it blows up again. He's subjected to abuse by Ms. Paul. He then goes back and kind of says, okay, I'm going to stop it, and then comes forward.
But if I understand your argument, you're saying it wasn't until she threatened to interfere with his work life that's what prompted him to file for protective
No, he
order?
filed actually because of the most recent incident when he decided to break the cycle.
All right.
I'm just showing the audio to say why he was afraid to do it sooner. That's
okay. All right.
So that being said, Your Honor, I think there's clearly sufficient evidence under preponderance of evidence, especially with the charge and the plea of guilty, to definitely show that there's been subject to domestic violence. I don't think that's in many ways a difficult argument in terms of him granting a protective order under the statute. However,
I think
we have a competing protective
she's
order.
on.
So let's talk about that. We'll get into the response here, Your Honor.
Well, let's hear.
I don't know if it matters, and I'm interested to see if the lawyers argue if it matters if one gets granted and one doesn't, or if both just get granted. I'm not sure if there's an impact if his gets granted and hers doesn't. So I'm curious to see if the court addresses that. But there have been incidents between the two of them, and she is the one on probation for the prior domestic violence incident.
I want to hear Mr. Swinard make his case in chief first before we get into the response.
I'm happy to do that. Didn't know how you wanted to handle it, Your Honor.
All right.
So, but I'm happy to respond to that once we're ready.
All right,
So,
very good. And let me just ask too, Mr. McDonald, I don't know how much input you have as to whether the protective order itself should enter or whether it's more pertinent to the parent time issue.
I don't intend to argue whether either protective order should enter. I just plan to address parent
Okay,
time.
all right, thank you. All
Thank
right. All right, Mr. Swinard.
And that goes to the guardian ad litem. So, all right. Now that we have gotten past the part where my feed had some issues with sound, we are going to switch. Many of you just coming into the chat missed that chat voted for the 4-camera layout. However, we immediately got bait and switched because something went terribly wrong. And so we immediately got switched to the worst ever. So we're going to switch feeds one more time. We are going full like Goldilocks mode till we get it just right. And that's fine with me. So we had some audio issues on
A text that we
our feed at the beginning. And so we can't really go through the there was no sound part very easily, but now we can switch. So I've got you. Maybe we should have stayed with, I didn't realize that feed would get so wild with like another party popping in on the side, but we'll fix it in post. We'll fix it in post. So let us, now that we're switching sides and we're going to hear from the attorney for Taylor Frankie Paul, we will switch feeds over to hearing from Taylor Frankie Paul's attorney. So let me make sure we are queued up properly for that argument and getting to the right, I get to the right spot in the feed. Because it is, the sound is better, but that feed, I agree, was distracting and not ideal. So we'll have a little bit of an overlap, I think, of the lawyers passing off the arguments. But the argument from Dakota's attorney is that, look, Dakota is a victim of domestic violence. Taylor Frankie Paul is the perpetrator of that domestic violence. His restraining order should be granted. Talked about the items of evidence that the court has, audio recordings, video recordings, etc. And now we're going to hear from the other side. And yes, Tracy in the chat asked, won't protective orders affect custody disputes? Yes. However, if both parties have protective orders against the other, we're going to end up in the same place, and the guardian ad litem is going to address it when we get there. So let me move this screen back now that we aren't trying to essentially modify. We're doing it we're doing it in real time as we get a better screen layout, so it will look a little bit more normal. So hang with me for just a second as we get that back to where it's supposed to be, because we're here live. I'm not a cat, but these are the things we normally do before stream is live. The stuff you guys don't normally see because we deal with it before the stream is live. But now I can move. This can stay here. It looks much better. I can move me and it will look much better. And then, no, that's the wrong one. Stay there. This is why I love having our own software, because now we can do these things. Okay. Let's get back to court. I know, good times.
A difficult argument in terms of him granting a protective order under the statute. However,
There we go.
we have a competing protective order. So let's talk about that. We'll get into the response here.
This
Your
is the end.
Well, I want to hear Mr. Swinner make his case in chief first before we get into the response.
Honor. Happy to do that. Didn't know how you wanted to handle it.
That's the end of the argument down here at the bottom from Dakota Mortensen's attorney. Dakota is sitting there in like the bluer suit. Taylor Frankie Paul again down here at the bottom in like the neutral color dress. And then the guardian ad litem is sitting over where my court bug is sitting right above that. The bug I cannot move. I can take it off, but that's where the guardian ad litem is sitting over there. All right, continuing on. It's a very small courtroom.
All right.
So, but I'm happy to respond to that once we're ready.
All right,
So,
very good. And let me just ask too, Mr. McDonald, I don't know how much input you have as to whether the protective order itself should enter or whether it's more pertinent to the parent time issue.
I don't intend to argue whether either protective order should enter. I just plan to address parent
Okay,
time.
all right, thank you. All
Thank
right. All right, Mr. Swinner.
Because for the guardian ad litem, parent time is what matters the most,
May I approach,
right?
Your Honor?
Please.
I know my chat has been
For you that counsel has.
Is this from
freezing a little bit.
the thumb drive that I've already received from you?
Yeah.
Something new that I haven't seen before?
Oh, don't do that. Don't do that. Don't do that. Don't do that. Do you see the commissioner's face right now? Oh, girl. How dare you show up at this hearing and give me new shit that I haven't seen before? Untimely! 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 Your Honor, throw it at him. He's not going to throw it at him. Throw it at him! Untimely! Untimely! I'm backing that up.
Pertinent to the
That was funny. That's funny.
parent time issue.
I don't intend to argue whether either protective order should enter.
I'm
I just
amused.
plan to address parent
Okay,
time.
all right, thank you. All
Thank
right. All right, Mr. Swinyon,
Thank you.
This is Taylor Frankie,
May I approach,
Paul's
Your Honor?
attorney.
please.
May I approach? Here's some
Some
new
hard
shit.
copies for you that counsel has.
Is this from the thumb drive that I've already received from you?
Yeah.
Something new that I haven't seen before?
Everything's been filed
All right.
and provided to counsel already.
All right,
We have not submitted a thumb drive. That would be from Mr. Mortensen's side.
okay,
So if I
that's
understand.
right, it was from him, that's right.
Those are hard copies of things that had been filed, but the judge was just like, what are we doing? Also, because chat voted, we did pick the WebEx layout as media. We were provided access to the WebEx and the ability to stream it. So this is our WebEx feed, but you can also see where the camera person is standing here, which is why the camera has to swing back and forth between the parties, which is part of why we are here on the WebEx with Taylor's attorney arguing.
Right.
I just
But
want to
if
make
the-
sure
yeah.
that I've got the sequence down correctly in terms of how you want to proceed. My plan was to rebut their request for a protective order and then also drift into my client's request.
Exactly.
Okay, perfect. Well, let me start
that's
with,
actually a little bit
I think, the
better.
primary incident, Dakota's Exhibit 1. We can call this the Barstool incident from 2023. My client has zero excuse.
That is the incident that she's on probation for. And this is the lawyer that likes to name things. They're all going to have names.
Excuses for this. It's
I read
self-evident that something happened. It should not have happened. It is a tragedy that Dakota and my client's daughter were the victims of her actions. She entered a plea in abeyance for assault on Dakota. She's on track to complete her probation in a few months' time, I believe in August. Don't have excuses for this, but there is a little bit of context
She took
to
responsibility
add to
for
this
it.
incident.
She did plead guilty.
This was a very difficult time in their relationship. They were going through some challenges, of course,
You don't hit people.
compounded by the fact that my client was dealing with 2 recent miscarriages. Alcohol was also a massive factor in the 2023 incident, a factor that is no longer an issue. She has not consumed alcohol. As for Exhibit 2, I think
She
this is an important
hasn't?
exhibit as well. This is a video that depicts.
She hasn't? Cause I have some questions about that.
My client slapping Dakota while they were in an argument in her home. Now, my client understands she should not have hit Dakota. The court can take note of that. It's relevant evidence. We understand that. The video also shows some conduct on Dakota's part that I find concerning. Immediately before she slapped him, he took multiple steps toward him, physically squaring up to her.
Toward her?
Toward her, yes, emphasizing the extreme size and strength disparity of this case. I don't know how big Dakota is. I've heard he's about my size, give or take. When I stand next to Taylor, I feel like a monster. I feel like a giant.
Well, she didn't retreat, right?
She did not retreat. That is correct. But she responded how a lot of folks would. She felt threatened
Yep.
if you get in her face like this. He tells her, hit me. And she did, unfortunately. After she slapped him, he berated her while laughing in her face, telling her to shut up. You're toxic as shit. You're fucked. I hate you, and I hate you more than anyone. It's an ugly encounter between these two parties. I think both acted inappropriately.
I mean, those are the things that were said. I actually do appreciate the lawyer not trying to mince words on that, because that's what happened in the incident. In the chat, Nerfio2 said, why is counsel testifying? This is argument to the court. regarding why the protective order from Dakota against Taylor should be rejected. So this is the argument against it. So the lawyer is arguing, and the court has the video on this one. So the court has seen the video. So it's lawyer argument based on the things that have been admitted to the court in evidence in their written motion. Those things are sealed.
And so I think the court can take some note of that context here. The court was particularly concerned at the April 7th hearing regarding the May 27th, 2025 pushing video, where my client, it depicts her unsuccessfully, I'd say, pushing him out of her home. Now, as she stated in argument on the 7th, as she's repeated and reiterated in her declaration submitted yesterday, she should not have pushed him. The court is justified in being even more concerned about this by the fact that Dakota was holding their son. She acknowledges that. Leading up to this incident, so as you know, Your Honor, it's a brief video. Clearly, there's something going on before the video that resulted in this. And there's also additional context afterward, once Dakota stopped recording. Leading up to the incident, in the days leading up to the incident, Ever had been very ill. And that's a 2-year-old son. Ever had been very ill, and they were having a hard time getting on the same page about how to treat him, how to help him. She feels that leading up to this and during these discussions, he blew her off when she was trying to bring him up to speed. This created a lot of frustration, a lot of tension in the room, so to speak. He came to her house for an exchange right before the video starts. Tempers flared, and she demanded that he leave her home. He did.
By exchange, they mean custody exchange. Taylor asking Dakota to leave seems to be a fundamental point in all of this repeatedly.
Did not. This is a familiar pattern in this case. The video picks up with her yelling at him and demanding that he leave. He doesn't. He decides to tell her no, and he lectures her. She then attempts to push him out of the house again while she's holding Ever. Right before he stops recording, she loses her footing and he calls her a fucking bitch. At that point, the recording ends, but what transpires is extremely important for the court to consider as well. And this is rebuttal information, but also something that we would believe give ground to something that we believe would constitute grounds for a protective order in Taylor's favor.
Okay, but
she falls to the ground,
yet.
Falls to the floor in her home, and Dakota kicks her multiple times, primarily on the leg. Our Exhibit A, and this is a brief correction, Your Honor.
And at what point does anyone call the police? Right. She's on probation during this period of time, and she does not call the police, and neither does he. In all of these instances, it is third parties that call law enforcement.
May 25 incident.
This is May, yes. There are other pictures that you'll see of injuries to Taylor. Those came in the aftermath of the February. In there, yes. So I'll walk you through this.
Or the ones that were attached to her petition.
Yes. So both. Exhibit A is exclusively related to May 2025. And so I can walk you through those.
I've seen them.
Okay,
The
you've seen
question I
them.
had was, there was reference to gushing bloody nose, but I
Different,
didn't see any
different
photos
incident.
about that.
Yep.
Yeah.
So that's February. We'll get to that in just a moment. So Exhibit A, as you can tell, this is multiple pictures, I think 5 or 6 pictures depicting
So the court
significant
already
bruising
has
on her
these.
leg and wrist, all over her leg, shin, knee, front, as well as the side of her thigh. Understandably, she was still fuming about this incident the next day
Well, how's she representing that she sustained those injuries?
while she was on the floor after losing her footing.
From him
She was kicked
kicking
several
her,
times
is
by
what
Dakota.
A lawyer just said.
All right.
The next day.
After the video had
Exactly.
stopped.
Yep. The next day, she's still upset about this, and they're tense in their parenting communications, having some challenges here. So she
Yeah.
demanded an apology from him. This is in our Exhibit J.
Mhm.
She demands
I was wondering what the bailiff was doing.
that
I got distracted. What's the bailiff doing? Getting her water jug. The bailiff is just, yep, getting her water. I was like, why are you walking over to council table? Water. Stay hydrated. I mean, fair.
This is halfway down the page. You apologize for kicking me while I'm down on the floor. His response is, not in a million years after what you did to me and my son.
Are you saying that's an admission that he kicked her?
Yes, it's a tacit admission. He does not use the words, I, Dakota Mortensen, kicked you, Taylor Paul, multiple times on May 27, 2025. But this was the day after. She clearly confronts him with this allegation. You kicked me while I was on the floor.
And he doesn't say,
and
I didn't kick you. What are you
passes
talking about?
by. And he just tacitly acknowledges
Right.
the allegation.
I don't know how the commissioner feels about that
At
based
the
on the
previous hearing, I
facing.
commented, maybe optimistically, I commented that both sides probably wish they could have taken this one back and approached their actions and conduct a little bit different as it relates to May 27th, 2025. But I was wrong. From Dakota's declaration, his arguments, including the declaration he submitted 2 days ago, he describes a story in which he did nothing wrong. We believe the evidence contradicts this. The closest he comes is an allegation that's not in the video, actually, where he grabs her arm, grabs her wrist to remove it from his shirt, and that's how she got, that explains one of the bruises. And his explanation is, well, she bruised herself by spinning around on the floor, which, again, I don't think is credible under the circumstances with the extent of the bruising, as well as this text message in which he, could have refuted this. Related to some of the pictures that he submitted, I mean, these are obviously very difficult for us to respond to, Your Honor. They're, in some cases, several years old, provided with minimal context, not submitted along with the initial request for a protective order. It's obviously a lot easier for us to respond to the video that he submitted, the videos that he has submitted, but we would just point out that she disputes the injuries that are sustained, that are depicted in these various pictures in Dakota's exhibits.
Disputing them in what way?
She has no, it would be foundational, and she has no knowledge of the incidents.
Of the injuries?
Yeah,
photographs
exactly,
of his
depicted in the
injuries?
photographs, in most cases being quite old. So naturally, she'll have difficulty responding. Exhibit 9 is an interesting video. It depicts Dakota and Taylor getting into an argument in her home while he's with Ever, I believe picking Ever up, spending some time with him in his room.
Is this the same date?
They get into an argument, and Dakota starts the recording, has it in his pocket. They get into one of these verbal arguments. She tells him to leave.
What date?
He does eventually. She entered the room, did not kick the door down, as he alleges. He tried, in the video, as you'll hear, he tried to get her to admit, you just kicked the door down. And she does say, okay, but it's very curt, very abrupt in an effort to disengage and get him out of the home. Like, okay, Dakota, just shut up and get out of the house. That's how I interpret the tone of the response. It's not an actual admission of, I kicked this door down.
In her own home?
I want to draw the court's attention as we transition now into the events of February of 2026. I want to draw the court's attention to our Exhibit I. This is the police report. A lot of interest raised by the court, understandably, at the April 7th.
At the April 7th hearing, the court wanted to know what was going on with the incident from February. And now we know that law enforcement is not charging anyone with regard to that incident. He called it the truck tussle. And yes, Chad, I agree with you. If he's going to argue tacit admissions, it's going to go both ways, right? So this is getting to that incident in February.
7th hearing about the status of the police report. Where is it? Do we have it? What are the investigators going to do? Are prosecutors going to file charges against any of these folks? Great. And that makes it easy for me. I'll just go cover.
Counsel, the court's read it. He means you don't need to tell him what's in it. You need to argue what point is made by it. He's read it. The court's prepared, counsel. Just keep going.
right down to the chase with the police report. We submitted this as our exhibit yesterday morning. As the court has already seen, pages 3 through 17 of the police report contain the meat of the investigation, of the findings. And you'll see they did their due diligence. They kicked over a lot of rocks here. There's multiple verbal and written statements from both parties. Both parties submitted pictures. Dakota submitted some videos. As I interpret it, it's largely the same body of
Argument,
evidence as
counsel,
what's been
what's your
provided
argument?
in the respective protective order matters. Very, very large degree of overlap. And this, importantly, is centered on the allegations that took place on February 22nd and 23rd. And in all candor, I think it is helpful. You've already read this, Your Honor, so this won't be...
You can read relevant passages if you want me to,
Sure.
if you want to highlight those.
I'm just looking at one that kind of encapsulates what happened, because obviously as outsiders of the investigation looking in, you always kind of wonder, you'd like investigators, prosecutors to kind of show their work, provide their analysis as to their findings. And on page 16, the city prosecutor, this is the investigator's recitation of the prosecutor's analysis on the case. And I'm reading this to be candid, Your Honor. This cuts both ways. This is a mixed bag for both parties. It certainly doesn't completely absolve my client.
Look at his
I understand
face.
that. But I do think it is relevant. So I wanted to.
The thing is, counsel, you're not going to absolve either party because the right result is probably that they both have protective orders against each other and stay away from one another. Right. And the judge is just like, yeah, okay, if you must.
Just read it briefly. It says on March 20th, 2026, the city prosecutor provided me, this is the investigator speaking, with an analysis on the case. She advised that neither Taylor or Dakota are credible witnesses, with both their statements being fraught with inconsistencies, such as Dakota's statement to 911 and Taylor saying she had a bloody nose with no evidence of that being true. That Taylor most likely injured Dakota on February 22nd, ripping off his necklace and causing the injuries she sustained. And causing the scratch to his neck in the process. Dakota causing injuries to Taylor on 223 while in the truck, because the injuries she sustained do not fit him pushing her off of him. The injuries are more consistent with him grabbing her head or neck and shoving her head against the dash,
Which is
and
what
that
she says
both
happened.
parties are misrepresenting their behavior. Also, Dakota had told her that he had not spoken to DCFS, and when she had spoken with DCFS, they confirmed they had spoken to him multiple times. They then conclude that DCFS might be the best way to help these folks.
There's no criminal charges, either way,
Either way,
at least at this point.
city or county, no criminal charges against
And-
either party.
The DCFS investigation is still ongoing.
No, it's completed.
All right.
And I'll give a full update on DCFS in just a moment, Your Honor.
That would be
So I think that's an
helpful.
important point. So we mentioned bruising.
For those of you asking which attorney is speaking, this is Taylor's attorney speaking about what the city prosecutor said, because both the city prosecutor and the county prosecutor evaluated this case. Numerous attorneys evaluated this case and found that they weren't moving forward with criminal charges.
Exhibit A, as I mentioned, relates to the May 27th incident. There are a few, this is an overlap with my clients. It is our Exhibit E.
Literally exhibity.
If we look at pages 25
Full exhibity.
through 27 of the police report, you'll see the bruising. You'll see a compilation of the bruising that's referenced there. Page 25 is the large bruise and swelling on her forehead.
Same pictures that were attached to the petition. right?
Yep.
There's one different one. There's one additional one that I can show you. That would be on page 26
Of the,
of the police.
The commissioner's prepared for the hearing and is like, counsel, can you just point me to what you want me to look at and make your argument? That's it. Just can we, I've already prepared. So the judge is like, I have already prepared. I don't know why we are hemming and hawing. Just tell me what you need to tell me. And then point me to the exhibits you want me to see. Much more direct.
Police report.
what's the exhibit number?
That would be Exhibit I, Your Honor.
How far into it? It's a long exhibit.
Right, it's numbered. I'm looking at page 26.
Okay, 26 of 34, where
Yes.
she's wearing a red.
Yeah, and you can see the bruising on her shoulder. This is her left shoulder.
Okay,
So see how these pictures tie together. So we go to Dakota's allegation.
this is still from May, right? May of.
No, this is related to the February 23rd
Oh, I
incident.
see. The one where you said we didn't have any videos of.
Correct. So this sequence of pictures, again, relating to February 23rd in the truck, neither party, there were no other parties present, no recordings, no audio recordings.
This began in the house, right? And they moved out
Yes.
to the
To
truck.
the truck,
The child
yes.
was sleeping at the time.
Yes.
Okay.
So they were intimate in the home on the 23rd, and then
What?
This was at her place, right?
her place in Draper. Dakota wanted to talk about the relationship, knowing the volatility and where these often go,
We don't need to know. Maybe we do need to know that they were intimate before this fight popped off. But yeah. The thing is, this is the moment she is back from recording The Bachelorette. So she is supposed to be in a relationship or whatever with, well, if she picked somebody, this is like right after she records The Bachelorette. Like right after. Oh. But yet, here we are.
folks getting very animated, yelling at each other. Taylor acquiesced on the condition that they go outside. So they went outside. Dakota drove away against her wishes with her in the car and then assaulted her. And this three pictures,
Away from the house with the child alone inside the house.
correct.
2 years old.
Yes.
Yeah, the court doesn't like that at all.
So
How far?
Yeah, Your Honor, I don't like it either. The court doesn't like this at all. I don't like this at all either. They go out to the car to fight or to argue, or to what have you, to verbally argue, I think was the intent there, to not wake up the kid if you're hollering at each other. And he drove off with her in the car. That's a problem. And the court is just like, what are we doing? And this is what the guardian ad litem was concerned about at the last hearing. That they are so involved with fighting with each other that no one's paying attention to being a parent. That is what the guardian ad litem is concerned about.
Away.
well, as he tells it, he kind of did a loop. So he stayed in the vicinity,
Okay.
but drove away against her wishes. The reason these pictures are important is because what happened, right? You've got two different narratives here that are at odds. We're in the truck on the 23rd, and they're both pointing their fingers at each other as far as, hey, they assaulted me. These pictures were extremely relevant and persuasive to law enforcement because Dakota's narrative is she went crazy and I had to kind of fight her off of me. And in that scenario, in that sequence, yeah, I did, push her head against the dashboard. He admits that in writing to police, but it's within that context of it's defensive. But the prosecutor and
Have we shifted from response to his petition to
It's a fair
initial
question.
argument on hers?
yes,
All right. Okay.
if that's okay.
That's fine.
Okay,
Judge-
all right. And it's a bit of both.
The judge had asked you to respond to their arguments before you made yours, and he's kind of jumping around, and the court clocked it, of course, because both of them have petitioned against the other. He was supposed to be responding to the petition, but now he's arguing his own petition, and the court clocked the shift in argument immediately.
I mean, if both sides are claiming assault as it relates to February 23rd, there's going to be some bleeding over. So,
Okay. All right.
Better phrase, counsel.
So with
Better
that
phrase.
clarification, Your Honor, again, investigators and prosecutors looked at this sequence of pictures provided by Taylor, and they contradict what Dakota said about what happened on the 23rd. These are not defensive bruises that Dakota inflicted on her. These are bruises that depict her left shoulder. So again, she's sitting in the passenger seat. These depict him forcefully grabbing her shoulder and sending her right into the dashboard. There's also a picture of bruising on her arm, which occurred during the same incident when he struck her.
And again, this incident from February 23rd, we had heard much about because Dakota, or someone who knows Dakota, shared it with the media. So details about this event have been coming forward for since March, right when The Bachelorette got canceled. A mutual friend, I think, or a friend of Dakota's at least, was the one who called law enforcement when there were scratches on Dakota's neck. Dakota's side of that is that Taylor attacked him and broke a necklace off his neck and scratched him on the neck, but that he grabbed her and checked her into the dashboard, and that's what caused, her injury when this was happening in the truck. So that's the incident that they're talking about. But when prosecutors evaluated this incident, they said both parties are unreliable in this, and we're not charging either party because both parties are inconsistent in how they are discussing what happened.
Now, again, we've switched gears a bit and kind of drifting into my client's request for a protective order. As it relates to Dakota's conduct, my client has seen patterns of abuse and isolation, harassment over the years. And she would like to highlight just a couple of things that kind of speak to his inclinations, speak to what his desires are for her, his possessive nature. We have submitted as our exhibits B and K a very small glimpse into his obsession over Taylor, his inability to move on and leave her alone. Perhaps the strangest exhibit of the hearing will be our exhibit C. It's a 3-page sequence of pictures that depict a tattoo that Dakota received on the inside of his lip, his lower lip, of Taylor's initials.
When?
This was done without her knowledge, without her permission, and during an extremely difficult time in their relationship. It was unwelcome. She told him that. As soon as she found out about the tattoo, she told him that, labeled it creepy, and he just doubled down on it and denied that there would be anything objectionable about it. Dakota does attempt to muddy the waters in his statement filed this week. He does attempt to muddy the waters on this issue. He attaches a text message in which they claim, Taylor implies that she liked the tattoo, finding it quote unquote hot that he had the tattoo. That is not a fair reading of the text message.
Are we really arguing over a text message about whether she thought the tattoo was creepy or not? The judge gets to decide. And the judge is looking at them like, y'all both need to stay away from each other. I think the court is like, y'all need to stay away from each other. The reason they're bringing this up, because a lot of you are like, why in the world is he bringing this up? I think because he is going to argue that Dakota is obsessed. We heard him use that word just a moment ago in his argument. He is trying to highlight that Dakota's obsession with her is what's driving this forward, not her. So she needs a protective order because he keeps re-engaging. She's not the one re-engaging. He's the one re-engaging. That's why he's starting to bring this up, to argue that he is the one that keeps re-engaging with her, and then they fight.
It's clear that she's mocking him for having the tattoo. She's essentially telling him, I'll be thinking of your silly tattoo while I'm with other guys. It wasn't nice that she said that, but that is the context, and that is the correct interpretation of what she was attempting to convey, not meant as a dig at him. It was
meant as a dig at him. It was meant to mock him because she was off filming The Bachelorette. Right.
Meant as a dig at him, not a genuine expression. Another objection my client has regarding Dakota's conduct over the years that, again, shows his infatuation with her, inability to let go, his monitoring of her, is shown in our Exhibit K. This is at the very end of our exhibit packet, Your Honor. Very briefly, this demonstrates that there are two instances. There were two instances in which Dakota stole Taylor's phone. Specifically, if you read these, specifically...
This is him talking in this text bubble, in these text bubbles.
Yes. And so, for example, if you go... So, Exhibit K, pages 8 and 9. If you go to...
I'm curious about the monitoring.
Second to last page in this exhibit, that is page 8. What's being shown here is the first instance, did you steal my phone? So weird, and she confronts him about it, and he downplays it. The second instance is depicted on the final page here. You stole my phone again? He says, yep, wanted to read all the messages of you and Braden. She says, dude, you're a creep and it's illegal to be stealing from me. And
who's Braden? What? Chat, who the fuck is Braden? I have no idea who Braden is. But yeah, I would worry that there was tracking software on her phone. If somebody has physical access to your phone, they can put all kinds of shit on your phone. Don't just start using it again, because the amount of shit that you reset the phone, reset the phone, reset the phone, reset the phone. Okay, continuing on.
Dismissive response was, oh, call the cops. So he didn't understand that he had crossed a boundary, that this was invasive, that it was at a minimum improper for him to be observing and intruding on.
Okay, so Soko SLP said, shit, Braden is my son's name. He just said, what the fuck did I do? Braden, you didn't do anything. And I don't know who the Braden is from here either. We're also just confused. Also, apologies, Braden.
These communications that he imagined she was having. Finally, Your Honor, I do want to, as it relates to his abusive conduct, I do want to touch on something that is a little unusual about this case.
Okay.
There are a few aspects to it that are a bit unusual, but this is one that my client and I find, I think, relevant, and that is
TV.
A very public leak of the 2023 Barstool incident to media outlets.
I think that's fair.
One specific media outlet, TMZ, on the same day that Dakota filed his amended request.
You're
for a
talking
protective
about
order.
the affidavit from Draper.
Yes.
Okay.
Yes, she touches on that. Yes.
I think it's a fair argument to say, look, if he's saying he wants this to be resolved in the best interest of the child, why is he leaking this video to TMZ? I think it's a fair argument to bring this up, truly, because it's also a way that he's going after her. And we've switched into her attorney now arguing why she should have a restraining order, keeping him away from her, not just her away from him. And yes, we're back to the city of Draper. No, not Jesse Draper. No, city. We're now to the city. Oh, wait, shit. No, that might be Jesse Draper that he's talking about, because she just filed an affidavit like yesterday. So no, we're not talking about the Maverick and Draper. We're actually talking about another cast member on the Secret Lives of Mormon Wives, Jesse Draper, not to confuse it with the Draper and Maverick. Hopefully that helps. No, chat, you were correct. Yes. Let me back that point up just a little bit. Not Don Draper, chat. Not the Maverick and Draper. Why are there so many Drapers? Yes, the affidavit from Draper, not regarding the incident, Jesse, the other cast member.
And that is a very public leak of the 2023 Barstool incident to media outlets, one specific media outlet, TMZ, on the same day that Dakota filed his amended request.
You're
for a
talking
protective
about
order.
the affidavit from Draper.
Yes.
Okay.
Yes, she touches on that. Yes. So
Jesse
you're correct that a
just filed an
declaration
affidavit
from Jesse
yesterday.
Draper was filed yesterday afternoon.
Fuck, just keep reading, Emily. Okay. Yes. The affidavit from Jesse Draper.
And so I'll get to that in just a moment, but to provide a little bit of context, last year, my client, she was announced as ABC's Bachelorette. Filming took place in the fall. The season was supposed to have debuted on March 22nd. However, on March 19th, the same day he filed his amended request for a protective order,
Ever's
a
birthday.
news outlet published the video of this incident. Before this release, it had not been out in the public. So this was released 3 days before the big debut and coincided again with other actions he was taking with the protective order, as well as coordination, additional reports to law enforcement. I understand.
I think it's
he
a good
denies
point.
having done this.
No, he 100%. There's no other way TMZ has that watermarked as their own proprietary video if the person who recorded didn't give that to him. I just can't imagine. Bring Spicy Draco back. Because it didn't, even if someone else physically sent the email, he had to release the rights to it. Because I think he wanted to get the series canceled. I don't think it negates her also being abusive towards him. I don't think that negates it. And it shouldn't. But the court needs to consider the full picture. And here's part of the full picture. So Dakota had to have sold it to TMZ. True Virgo 4241 said, but if he owns it, is it illegal? It's not illegal. However, when they are talking about what both parties are doing to each other, this is part of the picture of what the parties are doing to each other.
But a lot of information lends itself to Dakota leaking this, or at least at a very minimum, having his fingerprints all over this.
I mean, I argue that he
in
leaked
addition
it.
to the timing, which is extremely coincidental, the declaration of Jesse Draper, which you alluded to, Your Honor, indicates that in the days leading up to the March leak, Ms. Draper entered the basement of her home, that's Ms. Draper's home, to find Dakota speaking with Ms. Draper's husband, Jordan, as well as Dakota's roommate, Chris.
Fucking hell. For everyone who doesn't watch Secret Lives of Mormon Lives, I am sorry, because now this is getting so into the weeds. But we are now deep into the weeds of the cast of Secret Lives of Mormon Wives. By the way, Jessie and her husband have since filed for divorce, but this is a lot of drama. This is a lot of drama. And of course, Jordan is in the middle of it. Because of course, Jordan is in the middle of it. Jordan is Jessie's estranged husband. I know that this, for most of you, it feels like listening to somebody tell a story about people they knew in junior high, and you have no idea who these people are. I totally get it.
True. And what they were talking about, she noticed that he was very animated, that Dakota was very animated. He was venting his frustrations with cops not doing anything, and told her he was going to take matters into his own hands to embarrass Taylor. He specifically told Ms. Draper that he planned on leaking embarrassing videos of Taylor to the press, starting with the Barstool video. He specifically named TMZ as the outlet, and a few days later, that exact video was released by TMZ. My point in bringing this up, Your Honor,
I mean, TMZ has ownership of it. TMZ has asserted ownership of it. They can only have it from the copyright holder, but oh shit. And I know, Chad, it's hard not to name call Jordan as well. I know. It's okay that he's not your favorite.
Is that it contradicts how he is attempting to portray himself today as someone who is really he does not want to come after her for custody. Excuse me, Your Honor. So our point with the video is he's not just trying to come after her for custody. He's not just trying to seek a protective order. He wants to literally destroy her. He wants to subject her and her family to a new round of torment. Yes, there are career implications to it. There are There's mass embarrassment associated with that. But ultimately, our big problem with that, my client's big objection to his conduct was, this additional harm and embarrassment and shame that he inflicted on my client as well as her children. This was a step too far, and we think shows his true nature.
All right.
Okay.
I do have comments on custody, but I'm guessing you want me to hold off on those for the time being.
Just for now.
Okay.
We'll come back to it.
Great. Thank you, Your Honor.
All right.
Okay.
Rebuttal and response.
Rebuttal and response.
So the reason it's rebuttal and response is because Dakota's lawyer made their argument for why Dakota should be granted a restraining order. And then Taylor Frankie Paul's attorney made his argument that she should be granted a restraining order against Dakota, but that he doesn't really need a restraining order against him, which is a hard thing to argue, that she needs a restraining order against him, but he doesn't. He needs to be restrained from contact with her, but she doesn't need to be restrained from contact with him. And the argument from her is essentially, I'm not the problem. He won't leave me alone. And then the other side of that argument is, I'm not the problem. She won't leave me alone. And so I think it's a hard thing to argue because at the end of the day, you just restrain them both from each other and go just move forward. So now, because we have heard from Taylor Frankie Paul's attorney, now we are going to hear from Dakota's attorney again on kind of rebuttal response on the other side of that. Crystal Dagger 1620 said, wouldn't it be simpler to say nobody can interact with each other? I agree with you. There are going to be reasons that both attorneys want the restraining order from one against the other, but not vice versa. I say everyone gets an order. None of you interact with each other. A third party neutral can help exchange the kids. That is how I think this needs to be handled for at least a year, for these parties to get away from each other and not have any contact with each other. I don't know how that's going to go, but also it would prevent, I hope, the parties from weaponizing the protective orders against each other. And we saw that in the Sarah Boone case, and we talked about it a bunch in the Sarah Boone case, with one party weaponizing the protective order against the other party. You do not want to set up a situation where that can happen here. Because do any of you think that that wouldn't happen? Whoever gets the protective order, that the other party wouldn't leverage it against the other party? Right. The only way this works is if they're both restrained from each other. All right. Continuing on with Dakota's attorneys.
Yes.
Right. And then when we get to the parent time issues, I'm going to start with Mr. McDonald.
Yeah, parent time's going to start with the guardian ad
Sounds
litem.
reasonable, Your Honor.
Very reasonable.
Okay. So let's take a look at, we'll do response first, as I think that will kind of square up, and then I'll rebuttal for kind of the entirety for that. So I see 4 allegations in her protective order against my client. I'll go through them line by line, Your Honor. The
Oh, that's
first
so
one, you've seen
organized.
our
We appreciate it.
declaration opposition with its exhibits. I'll try not to burden the court by reading it directly. Regarding the May 27th, 2025 assault, as you can see from our declaration, my client reports it was actually stricken before he turned the camera on. Once the camera's on, you can see her acting extremely violent against him. When he was able to turn the camera off, remember, he was holding his son. She was grabbing him. You see the information that we have here. We suspect her injuries were occurred from her.
I'm more interested in his explanation for her injuries.
So the wrist is likely because he had only one harm as holding the kid to try to get her arm off because he was trying to get out. She tripped. And I think the tripping and the kicking on the floor is likely where the bruises to her legs happened. He does not believe he ever kicked her at that point in time. And I do have some interesting bit about that.
He doesn't believe?
Well, yeah, he was.
I was going to say the same thing, Your Honor. He doesn't believe that he kicked her? Okay. Right. The court, I think, is just like, no, we don't. No, both of y'all are a mess and you need to stay away from each other.
The kicking on the floor is likely where the bruises to her legs happened. He does not believe he ever kicked her at that point in time. And I do have some interesting bit about that.
He doesn't believe.
What, she just like happened to find herself under his feet? Is that she was just in the way? Where are we going with this, counsel?
Eve?
Well, yeah, he was being assaulted, so it's
All
a little
right.
hard to figure out exactly where things were, but he will definitely, if I called him to testify, I would testify he did not intentionally kick her in any way. But when you have someone falling on top of you and you're trying to get away and you're trying to hold your son, legs can kick out, you can fall backwards. He was trying to hold his balance. He
Did
stepped
the
on a
video
toy.
shoy him falling down?
No, the video stopped before that. That's the unfortunate.
He was able to turn it off while he's falling?
No. He did not fall. He started to fall as he fell on the toy, tripped on the toy. And that's when he realized, okay, I've got to get my hand. So he turned it off.
All right.
That's what he says. And I think that makes a lot of sense, Your Honor.
If he was falling, how did he have time to turn off the recording and stop himself from falling? Why didn't the phone just fall? I have questions.
What I think is really interesting about that is the rebuttal exhibit that I did cite, Your Honor, is she indicates in the exhibit, I believe it's rebuttal exhibit 4, there's a text message stream where she actually indicates, and this is from a year, May a year ago, that she has her video of the incident and he has his. What I think is interesting about that, we've never seen her video, which leads me to believe she was either being untruthful and she never filmed it, or she did have a film and she's not showing it for a reason. And that's what I think is important, Your Honor. It does go to credibility. We're in a preponderance suit here. I do think that that's important to recognize. I also, really want to put this in perspective. He is holding his kid at the time. He's trying his best to leave the residence. And so that's where we're at. Also, as you can
That's
see
the May
here,
incident.
let's move on to the next one. I did want to address the police report really quickly, Your Honor, before I forget, because it's not detailed here. And that is, remember, police are always looking at beyond a reasonable doubt. It's a different standard of proof. These injuries, that was photographed, there is no, kind of nothing but her testimony or her statements that they were inflicted by him. And there's nothing but his statements as well.
Right.
This is
The
not some
February incident.
This is the February incident. There's nothing. No one recorded. Everything was done after the fact when police were called later. And that's the problem. And it was like, I think 2 or
What's
3 days
odd to
later.
me is that from May of 2025, there's video and
Mhm.
photographic evidence, but no charges either way.
I know, Your Honor. It's a little odd too.
Very
And
odd.
I'm a little surprised as well, especially since Ms. Paul was under court probation at that time. Or not just court. I think, well, I might have the date wrong. Correct me if I'm wrong.
No, she's
But
still
she
on
was under
probation.
AP&P probation
She
for one
is?
period of time, and then it went to court probation. So the fact that didn't come forward, it's why I mentioned.
The fact that they didn't ever violate her probation is kind of shocking to me. I am also shocked that they never violated her probation, which means either they didn't find the incidents went down the way that Dakota was saying that they went down. Because let's just talk about this for just one quick second about why it's shocking to me. Just give me a second. Because the standard for probation violation is incredibly low. It is not beyond a reasonable doubt. The standard for probation violation is a very, very low standard. And so when these incidents are coming forward and they are not being treated as violations of her domestic violence probation, it's shocking to me that they do not find any of these incidents worthy of violating her probation. It's very odd to me. So it's really, really odd for me. But okay. I mean, it's odd. So they're not seeing these incidents in a way that there's even a whiff that she was doing something wrong, which is surprising to me, given that we do have incidents where she is hitting Dakota, which violates her probation. So it's surprising to me. All right, continuing on. I saw a number of questions in the chat, including Barbie Crab 369. I hope I said that correctly. 369 is going to make me start singing. Some of you in the chat will get it. Some of you won't. But either way, yes, they can both be granted restraining orders.
Earlier, Your Honor, that stuff about him not coming forward. It's because I think that's the oddity, is why doesn't he tell the DA? Why doesn't he do these things? Because he was afraid.
Okay.
And so now let's head over to the February 22nd incident. You've seen our response, Your Honor. You know, we see text messages. She indicates in her protective order that he was harassing her and trying to come over and trying to hook up. The text messages that I submitted, extremely
Chad.
clear. She invited him, and she invited him for the sole purpose of intimacy. And I think that's extremely...
Chat, you always make me feel very at home. It's why I love streaming with you all. So thank you, chat. Thank you very much. They are now saying that Taylor is having Dakota come over for the sole purpose of being intimate on the heels of her just returning from filming The Bachelorette, which is probably another reason why this season will never see the light of day or the light of Hulu.
Trying to hook up. The text messages that I submitted, extremely clear. She invited him, and she invited him for the sole purpose of intimacy. And I think that's extremely why we keep seeing this cycle happening. And he did go over.
I just have to back up. I mean, they entered into this stipulation for 50-50 custody in June of 25.
I'm aware.
After this all happened.
Yes, I'm aware.
Okay.
And that's part of the problem, Your Honor, and I'll get to custody in a second. But
We'll get
that's
to it.
why I mentioned those issues, is that this is a man who I would expect a lot of male domestic violence victims is he's trying to make things work. He's trying for the sake of his kid. And he's still enticed. He still has this spark of romantic relationship that occurs, but then it's a cycle. Then it breaks down. Then there's an assault. Then there's a, kind of a, oh, I'm sorry, here we go. And you can see, like, for example, perfect case scenario on the 22nd incident where we're talking about the broken necklace. You actually submitted the text where she said, I bought you another.
She has a lot to say to her lawyer about that. Okay.
Necklace. Well, I can quote it, but I bought you another necklace for the 1,000th time.
All right. Okay.
1,000th time. That's a pretty good statement. These are
Oh, counsel, it's okay. Okay. But it's not just male victims of DV that are in this cycle that you are. This is the cycle. This is the cycle. We've watched the Sarah Boone. This is the cycle. The problem is this cycle can get very out of hand and very violent. And the commissioner is just like, But also the commissioner is saying if Dakota is relying on the incidents in May 2025 to say that he is afraid and needs a protective order, how are they able to then come to a custody agreement? So the commissioner is looking at what happened in February, and I think the commissioner is almost anticipating the attorney for Dakota to say the February incident was the final incident. That is the final incident. And because of this incident in February, this is where he realized that this is never going to change. And he went to law enforcement and he filed for the protective order, and he is taking an affirmative step towards breaking this cycle. And I'm surprised that Dakota's attorney's not arguing that, because he is the first one that went to the court to ask for the restraining order, and he initiated those things. So when they keep going back to older incidents, there are things that happened after those incidents that the court is bringing up. So I'm very surprised that we're not getting into the February incident being a point of change. But that's not what his lawyer's arguing. I'm surprised that he's not, because I think that's what you would argue. But I guess we'll see if he gets there.
being ripped off a lot. And he can find the
I don't think she's bought him 1,000 necklaces.
quoted, but I bought you another necklace for the 1,000th time.
All right. Okay.
1,000th time. That's a pretty good statement.
I mean, it's
These are being ripped off a lot. And he can find the information he can, but, and the pictures he can, but that's where we are. He gives a pretty good incident. I mean, you can see on the 22nd, That was the thing. She jumped on top, strangled him, pulled his necklace, broke it off. We have the text messages that support that. And then we have again, that one I do want to mention. He did call 911 that night. That was the first inkling because he realized, he looked over at his son, saw his son terrified and crying, and went, I can't do this anymore.
Oh,
can't
there's the
do it.
argument. Emily, keep reading.
I've got to take it. I can take it. My kid can't.
Are we
February
leading into
22nd.
26?
There's
February
that
22nd.
argument.
2026.
One where we don't have any.
No.
I had thought that a third party called 911. I did not know that Dakota called 911. Addie, is it Addie? Addie, I hope it's Addie. I hope I said that correct. Addie Martinez, realtor, said it has everything to do with the Bachelorette, and that's going to be Taylor's argument, right? That February wasn't a final straw. February was another way that he's leveraging control and trying to destroy her. That's what we just saw her attorney arguing. So I'm looking at this through the lens of the lawyer that's arguing currently, as I tried to do when we were listening to the other lawyer as well, who was arguing that Dakota is trying to destroy Taylor and her career and everything else. So I'm trying to see where each side is arguing versus arguing with them. So we are now in the February 2026 incident regarding the truck, which included a necklace being ripped off of Dakota.
Video.
No video.
Okay. And in that incident, he does call 911. And he regrettably, she said, please don't, please don't. And so he makes something up and says, oh, we're wondering if the kid's sick, because the kid was sick earlier that day. It's not a lie, but he chickened out. He didn't tell police I've been assaulted. He didn't want to face that wrath. And so he left. The next day, February 23rd, it's the next day, early morning. You can see the text message we provided. She entices him again, specifically saying, come over here. I need intimacy. I'm paraphrasing it in a nice way because we have cameras, but it's not that nice in the text.
Similar.
No, counsel. What the fuck was said? What the fuck was said? What the fuck was said? There's no downplaying it anymore. I understand you want to make it look nice. The thing is, you're saying she entices him. Her lawyer is saying that he will not disengage, and as he's sitting in court looking at her, he will not disengage and got her initials tattooed on him when she was going off to do The Bachelorette. And she's like, yuck, stop being a creep. I'm going off to record The Bachelorette. We just have to mention it all at this point. Because, well, the other attorney did.
Kind of behavior himself.
And the court has clocked it immediately. The court's like, come on now. This is not, because we heard on the April 7th, and I'm not going to mince words, but we heard at the April 7th hearing that he was sitting outside texting her, what's the problem? Do you want to fuck? Like, that's what he's texting her. So it's in the record.
Specifically saying, come over here. I need intimacy. I'm paraphrasing it in a nice way because we have cameras, but it's not that nice in the text.
Similar kind of behavior himself.
Yes.
In that regard.
Yeah, there is some of that as well. Yes, of course. But
I also don't think it helps counsel's argument when there is no admission of what his client is doing and all she's doing this, she's doing this, she's doing this. Her lawyer took a different tactic. Her lawyer said, look, she's done these things. Here is the context around those things. Those things are inexcusable, but these are the things he is doing, in addition to the things she is doing. His lawyer is taking much more of a, she's doing this, she's doing this, she's doing this. And I don't think the commissioner is being very much persuaded that this is a one-sided circumstance.
Requesting or having, sexting back and forth is not grounds for a protective order. But in this case, I'm presenting it because it conflicts with her narrative that he's this stalker that is somehow always hitting her up or going there. She specifically requests it. He specifically goes on the 23rd. They have a whole discussion about where they're going to be able to do it because it has to be downstairs because the kids are there and they're sleeping and this and that and this. And they go down there and the same thing happens. But this time, She throws things at him. She throws his phone, breaks into the wall. It like sticks into the drywall and he had to pull it out. It's probably why he didn't record.
What?
And then he runs out to the truck. And while he runs out to the truck, she follows him. And she was trying to block him from leaving the residence. It's not the actions of someone who's.
So here I just have stories, right? from
This is
each
just
of them.
stories.
Yeah.
We just have their story and our story.
Proffers of testimony.
Proffers of testimony. And he says that she.
Except maybe for the one exhibit that she said occurred from what transpired in the truck, right?
Yeah, well, we have the police report, but their statements pretty much follow exactly what we're saying here, Your Honor, which is, he said.
I mean, wouldn't the police have photos of a phone-sized hole in a drywall? Because that's a lot.
That, and it's my client, that, and I think if you look at the history of this case, it's the more credible retelling, that she follows him out. She blocks him by getting in his passenger vehicle so he can't leave because he says, this is it, I'm calling police, I'm done. Okay? She doesn't want that to happen. She follows him because she has got a lot on the line. She follows him, gets in the car. This has happened before, he would testify. He's like, I don't know what to do. She sees a text message come through or a phone call come through from some girl that he's seen. She starts kicking and busting the video screen thing that we have, in our trucks or our cameras in our cars.
Excuse me, counsel. Are you referencing the infotainment system? That would be the infotainment system. We know what that's called now. We do.
Didn't break it, but she was hitting it. Then she starts, striking him. He's like, well, I better, try to get out of here. So he starts driving. He starts driving around the block. Hopefully she'll calm down because he's good at calming her down usually.
And this is all led to the police report.
This does.
That said that concluded they both had credibility issues, right?
Yes.
That's correct, Your Honor. The police report believed that. I don't think my client has credibility issues, but I think when the DA's office is looking at it, they're going to make a call, and I would humbly suggest that they didn't want to get involved in this. So they said it both ways. But credibility for her, I mean, we've got proponents here, Your Honor. The next up is just to
I
cover
hope
it,
that that's not true.
she started interfering while he was driving by squeezing his face, taking him. That's why he throws her off of her. And that's where I need to cite a statute, Your Honor. I
Wait.
think that's the important thing
Yeah,
for this.
Who throws who off of who? Counsel, we're having pronoun problems again. Who is... Huh? This is a fair point. Kaylee in the chat said, how did she see a text if she broke his phone? Excellent point, Kaylee.
Photographs from that
No.
incident?
No. Well, I mean, later, with the police, they took the necklace and stuff like that. But
Right.
squeezing the face, I mean, it didn't.
I haven't
leave any
seen those,
marks.
have I?
The necklace photos were in our original exhibits.
In your
Your
original
The scratches,
exhibits,
yeah. But here's what's important. I think we need to quote here. Section 78B 7108, mutual protective orders. I don't get to refer to this statute very often. When two parties.
Well, we're glad for you, counsel. Mutual protective orders sounds like a great idea. Oh, this is a good point. Waiting for Friday said text can come in over the infotainment system too. Excellent point, chat. A number of you said that. If he's got like CarPlay, it could come across on Apple CarPlay. Fair point. But so the phone is at least on and still linked to CarPlay. Excellent point. See, here's the thing. We need more information. Maybe that's why she was kicking the infotainment system.
Quote here. Section 78B 7108, mutual protective orders. I don't get to refer to this statute very often. When two parties have filed protective orders, the court may not grant a mutual order or a mutual civil protective order to opposing parties unless each one's filed their own. That's happened. And there's a showing that, there's basis for it. But it becomes the party's burden, including Ms. Paul's burden, to demonstrate that the abuse or domestic violence she's claiming did not occur in self-defense.
Interesting.
We're saying it's self-defense, Your Honor.
Okay.
He had to stop the attack. He did push her off. It's possible she got a bruise to her head. He didn't see anything. He didn't see a bloody nose. She said her bloody nose. He went back the next day. There's no bloody nose. She's not saying anything. It's in the text messages. We think the credibility there is It's very easy for her to, if she's attacking him, to harm herself or to get hurt by hitting him. It's very easy for her to push. He is stronger, and she gets thrown into the door as he's trying not to crash the car where the kids are at home alone. So he goes there, he pulls off, she gets out, and here's what's interesting. Okay, and this is why I struggle with the credibility of Ms. Paul's statements. That right after that happened, she proceeded to call him 11 times, and we submitted those phone logs. You can see them 11
And he
times.
was texting her.
And in the very first one of the calls, he would say, because it's not recorded, it's called, she actually says that phrase that she then used later to say he's this harasser, so you don't want to fuck. That's what she said in the first call after this whole thing happened. That's what she says. And which he was like, what? What are you talking about? He said
boy.
no. He gets 10 more calls from her. It's in the phone logs. We submitted them. Saying that they should return. She then says she has a bloody nose. He's concerned, so he goes there because she says, again, using the kids, I need to go to the ER. Someone has to watch the kids. He goes, tries to get in, knock on the door. She won't. Sees through the window. She's there. There's no bloody nose. And so he leaves. And you see the text messages that we provided. You can hate me. It's valid, she says. He says, finally, the intimate relationship's over. And we submitted those text messages. I think it's really important that he's finally had the courage to break this cycle, Your Honor. But I need to respond to a couple other things as well. So next up.
Somebody needs to break this cycle. I think mutual restraining orders is going to be probably the right result. But you see what Dakota's lawyer is arguing, that he doesn't want the mutual restraining orders because he is saying this is not mutually combative, that his client is acting in defense only, and that's why they should not be mutual orders. That's his argument.
Oh, here it is. Harassment. She claims that there's been harassment in this case. I do need to cite what the definition of harassment is, Your Honor.
Okay.
Harassment, as defined by, and the Protective Order Code does.
We love going to the law.
76-5-106, which is the criminal code for harassment. An actor commits harassment if, with an intent to frighten or harass another, the actor communicates a written or recorded threat to commit a felony. There's no evidence of that here, Your Honor. That's not harassment. It's not a basis for a protective order. February 23rd, we've covered. February 14th, the harassment and stalking. Again, for stalking, Your Honor, I need to cite Meyer v. Potion, a case I'm sure you're familiar with. In that case, it talked about the reasonable person standard. It's not whether she feels it's stalking harassment, Your Honor. It's what a reasonable person would believe. And falling into that, when we look at it from an objective standard, the one piece of evidence she really draws on is this tattoo. Okay?
I mean, he does end up often where she is. The flip side of that, though, is they are recording a reality show together, which makes all of this really, really, really messy.
Oh, and just because I forgot about it, but in Exhibit 10, which happened right after the incident, the 23rd, we showed you the phone logs. She made 151 phone call attempts to him between 2 hours.
I have questions about whether that's from the phone logs or whether that's from the carrier records, because here's my question. They keep talking about the phone logs from the face of the phone, but in some instances, they're talking about the carrier records. So they showed that the 11 calls were from the carrier records, but they're saying that the 151 phone calls are from the call log on the phone. But if you have the carrier records for the other calls, why don't we have the carrier records for all of it? I would like to see the consistency in it, because the Proud Boomer in the chat asked, is there a difference? There can be a difference. Here's why. Because if someone, like, you could change your number in the phone. I could change Dr. B's phone contact info to whatever name I like and show, look, this this is who's calling me. So you can change your contact info in a phone to any number and have somebody calling you, or have another phone and do it yourself. So phone records that just show the name that's calling could be manipulated, but carrier records are much harder to manipulate. It would show the inbound, outbound number. So, you know, Dr. B is saved in my phone as the doctor, because then I can say to all my devices, call, you know, and then wait to see if a TARDIS ever shows up. It's delightful to me. So I'm interested to see if we are going to have the court ask the difference between the carrier records and the phone log that on the phone is just showing there's 151 calls. I have questions based on how these parties have engaged. I have questions. So, all right. We ready? I'm curious. Yes, you're welcome, chat. Look, it needs to be, look, when it's the person you're engaging with on the phone the most, it needs to be amusing. Also, all of my DA friends are saved in my phone, not under their real names. We have a whole code going on. We'll talk about that another day. Continuing on, though, I have questions about the 151 calls, because it's a lot of calls.
Familiar with. In that case, it talked about.
I'm going to back that up just a little bit, because he very much says the phone logs, not the carrier records.
The actor communicates a written or recorded threat to commit a felony. There's no evidence of that here, Your Honor. That's not harassment. It's not a basis for a protective order. February 23rd, we've covered. February 14th, the harassment and stalking. Again, for stalking, Your Honor, I need to cite Meyer via Potion, a case I'm sure you're familiar with. In that case, it talked about the reasonable person standard. It's not whether she feels it's stalking harassment,
Sorry, I backed up
Your
too
Honor.
much.
It's what a reasonable person would believe. And falling into that, when we look at it from an objective standard, the one piece of evidence she really draws on is this tattoo. Okay? And, and just because I forgot about it, but in Exhibit 10, which happened right after the incident, the 23rd, we showed you the phone logs. She made 151 phone call attempts to him between 2 hours. It's not the behavior of someone
That's a
who's
lot.
afraid and worried that she's been abused. Behavior of someone that's afraid that the abuse is going to come out. So February, it sounds bad. You know, when I first heard about this tattoo thing, I went, geez, Dakota, what are you doing tattooing something on the inner of your lip? And he gave me an explanation I wasn't prepared for. Makes a lot of sense. It was a
I mean, those tattoos do fade pretty fast. But also, why get the tattoo? I guess we're going to find out.
filmed segment of the TV show, Your Honor.
It was for TV. It was for TV. That's the argument. Your Honor, it's just storyline. These two should not have been filming together from the very, very first incident. After she pled guilty, there should have been a protective order and they shouldn't have been filming together. And production doesn't like that answer, I'm sure, because them filming together is explosive. And production's right along for the ride, I'm sure. Go and do it. That's a great idea.
So, February, it sounds bad. You know, when I first heard about this tattoo thing, I went, geez, Dakota, what are you doing tattooing something on the inner of your lip? And he gave me an explanation I wasn't prepared for. Makes a lot of sense. It was a filmed segment of the TV show, Your Honor.
Not one we
All the
saw.
dads decided to go down to the tattoo parlor as part of the Secret Lives TV show. It was filmed.
This was Jordan's idea, wasn't it? This was Jordan's idea, wasn't it? This was Jordan's idea, wasn't it? This is some dad talk bullshit. Of course it is. But Your Honor, what about dad talk? Oh, okay. Okay, sure. But dad talk, Your Honor. But dad talk. Ugh. Well, at least we're learning more information. Look at the commissioner's face. I know you might have been watching the lawyer. I'm rewinding this. Watch the commissioner's face. Watch the commissioner's face. Nishay said, what the fuck is dad talk? Here's the thing. I can't, dad talk, chat can describe it maybe more generously than me. It seems like Jordan, one of the husbands who is now getting divorced from Jesse, was really upset that he wasn't getting enough attention. So he decided to compete with mom talk. He was going to start dad talk because they needed more attention. See, because they're not as compelling as like the husbands of the Real Housewives of New Jersey. And so they started calling it dad talk because they wanted their own segments on the show. Because they wanted more airtime. It's my opinion, instead of just letting their wives thrive. My opinion. So, dad talk is a plea for attention, even though the show started because of mom talk and because of Taylor Frankie Paul and a whole scandal. We covered that in other content. And they wanted to go to the Vanderpump Villa. That's right, they did. They wanted to go to the Vanderpump Villa. And they don't have genuine relationships the way we see in like Real Housewives of New Jersey, where there are times where we see the husbands being hilarious. I mean, drinking way too much, but also hilarious. So I don't like dad talk very much. It's weird. And I don't like it when they have airtime. So that's my feelings about it.
Your lip. And he gave me an explanation I wasn't prepared for. Makes a lot of sense.
Dad
It was a filmed segment of the TV show, Your Honor. All the dads decided to go down to the tattoo parlor as part of the Secret Lives TV show. It was filmed. It hasn't been released yet. They all get tattoos, and they all think, oh, it'd be so funny if you put Taylor's initials in your inner lip. And it's something else I didn't know until I looked into this. Inner lip tattoos, the reason why people do that is they fade. They are not permanent. They go away.
I have no idea whether that's accurate.
That is accurate,
And I don't
actually.
have
I will
expert
proffer my client's
testimony to that.
testimony. In fact, if you want,
One
I'll
way or
show
the
you.
other.
It's not really there anymore.
It's actually true.
so
That's true. And I bet this
that's
was
why.
Jordan's idea.
So it's not something that shows or permanently affects the bodies. What I think is really important with that is he was there with the group. It was filmed. When it comes out, we'll probably all see it.
No, I think they should cut that segment. I think they should cut all of the dad talk segments if this season ever airs, because I don't think season 5's ever going to air. And if season 5 does air, does this become part of season 5? Because this isn't TV and it shouldn't be. But this is a couple that I think is still engaging in this pattern, largely because their money is very, very connected to this cycle that they are in.
And what's important with that is, more important is that you could absolutely see in the messages that we provided, the text messages. Yeah, I mean, they're trying to say she was just horrified by it, but no, she actually talked about how she was, I'll say it's kind of, I mean, I'll soft sell it as a turn on, but my client would proffer his testimony right now that that very night of those text messages that you saw of her allegedly being freaked out about it and thought it was possessive, they were intimate that very night.
Counsel, two things could be true. Have you seen these two interact with each other?
So This is not a stalking, harassing behavior. These are two people that are on a TV show. They're
They shouldn't
doing all
be.
these different things to kind of make it interesting as TV is. But that's
it's
not
fair they did
stalking
resume
behavior. That's
filming.
not harassment behavior. Yes, my client will admit this is an inappropriate relationship. It needs to stop. That's why he filed his protective order.
Well,
But the main issue here, when you look,
the protective order did get filed the exact same day that the video got leaked to TMZ. So I have questions about whether it was initially for storyline or if he really felt that it was needed. I do have some questions about that. Also, the fact that she never filed a protective order, I have questions about as well. Sorry, I keep
I guess we're doing
pausing
rebuttal as well.
poorly.
The main issue here that we have is
Poorly
his desire
paused.
to protect his son. That's why he filed this protective order, is to protect his child, to stop the violence, to make both himself and her not be able to have contact. Now, this is a small thing. 150 days. It's not going to be that long. We've got a lot of work to do in the custody case. We've got DCFS involved. We're going to get to the bottom of this and sort it out and get some help. You've seen the videos, Your Honor. You yourself commented that there.
Can the judge make it longer than 150 days? Because I think that maybe is the right result. Can we just make it longer than 150 days? 150 days isn't enough.
There's some behaviors that were deeply concerning that we've seen from Ms. Paul when she gets emotional and when she gets aggravated. I definitely wouldn't want to be a child around that, and that's something we can work on. He believes she
drove
could be a
away.
great mom. She's a great mom when she's not emotional or not under these things. That's the problem. But
So she's a great mom when she's not around him, is what you're saying. She's a great mom when she's not emotional. Counsel. Okay.
we believe her protective order, which was filed minutes before the first hearing on April 7th, is not designed to protect her son. It's designed to protect her image. And her image has a lot of value. And so that's our argument in terms of credibility.
Not as much as it
I
used
also
to.
did bring, I can proffer the witness, Your Honor. I don't think it's relevant about this going downstairs and the witness hears them talk.
Do you think counsel was waiting for that line? Do you think counsel was waiting for that line? She didn't file it to protect her son. She filed it to protect her image. Do you think he was waiting for that? Because it feels like that one's on the notebook. Because didn't I just argue the same could be said of Dakota dropping the TMZ video leak and the protective order on the same day?
Talking about whether he's going to release the video or not. February 23rd video. We have a lot of February 23rds. The 2023 video. How about that? The one with the chair.
That's
the chair
better.
video.
2023 is better.
I don't think it matters from a legal standpoint whether or not he releases it or not. That's not a basis for a protective order. But just to show the credibility issues, he denies doing that, Your Honor. In fact, he told his publicist not to release the video. And I do have, Your Honor, someone who was downstairs with him, and that would be Mr. Crew Eaton, who's present, and I could proffer his testimony.
I read what in the police report. Apparently, he's the one that called the police, right?
Oh, the roommate? That's someone different.
Crew, he was the one.
Oh, no, the same person.
Yeah.
Yeah,
Yeah.
but Crew was down there at the time, and if I point to him, and he can correct me if I'm wrong, he would say that Dakota actually kept saying he didn't want to release it. Didn't want to release the tape. Like I said,
I
not
need to
terribly
hear more.
relevant.
Anyone can say, I don't want to release the video while it still gets to TMZ. Also, why does Dakota have a publicist as this video's getting released? Where is Morgan Tremaine? Also, the fact that the court has a better grasp on who the additional parties are than counsel speaks volumes.
Exactly. So, Your Honor, I'm happy to talk about custody if you'd like to hear from that. You said you wanted to hear from the GAL first.
I want to hear from the
but That's where
GAL.
we're at, Your Honor.
All right, I still need to give Mr. Swinyard the opportunity for rebuttal on Taylor's request for a protective order.
And after rebuttal, you'd still like me to sit tight on custody
Yes.
Yes.
before we drift into that?
Yeah.
Okay, understood.
I I have the domestic case too, so I don't know where this is all going to lead, to be honest with you. Are we going to keep coming back here periodically for time immemorial? We'll see.
The custody case is also before this judge. So this judge has the custody case and the and both of these cases. The guardian ad litem is the GAL, who's the lawyer assigned to look out for the best interest of the child. But now we're going to hear from Taylor Frankie Paul's attorney again to respond just to what the other lawyer said. So away we go.
Hopefully we can avoid that. The word cycle's been thrown around. A lot of back and forth, a lot of toxicity in this relationship for a few years now.
Yeah.
My client, she is taking accountability for her role in that. She's owning not just her participation in that, but the actual misconduct that related to it. We've gone through some of the allegations in the protective order, Mr. Mortensen's request for a protective order, and she's provided some context and some accountability for that. Mr. Mortensen does not own anything. He's not owning up to anything in this case. His strategy is extremely simple.
Do you agree with Taylor's lawyer in this? Do you agree with his argument that Dakota, in his argument, is taking no accountability or responsibility, and that she, in her arguments, has taken some? I'm just curious where you guys are at on that.
Deny everything. His only crime, as he tells it, is to give in to her advances. No mistreatment by him, no abuse, no violence of any kind. My client has shared her version of events regarding her request for a protective order. Again, the May 2025 incident does stand out. We got an interesting characterization of it today.
I do want to ask, and just from a credibility standpoint, she was texting him saying her nose was gushing with blood, but there never was a photograph of that.
Well, let's just keep the sequence straight. That was a different incident, which I'll come to in just a moment.
All right.
I know that there's a handful to keep track of here. But the May 2025 incident is her.
Because the court is also trying to figure out who to believe in this, or to what extent to believe or not believe either of them.
Pushing Dakota and Ever out of her home. That's the one I'm referring to right now.
Okay. All right.
So again, this one stands out because there is an admission, a text that we believe operates as an admission that he did kick her.
There's photographs too. Yeah.
Photographs of bruising, and
That's
counsel's
the May
version of events
2025 incident.
Came awfully close. I would say he did acknowledge that his client did kick Taylor while she was on the floor, but there was some
vagueness. He said he
vagueness.
proffered that if he were to take the stand, he would say he didn't recall kicking her.
Yeah,
No,
he may
I
have,
think he
right?
said he went full Sarah Boone with not intentionally.
Speculated that, well, it would have been a natural response.
And he was being attacked at the time,
Right.
is what his argument is, self-defense.
Exactly.
Yeah.
Yep, I understand the argument. I just don't think it's very credible under these circumstances, especially with the photos of the bruising as well as the text message. The February, now we're skipping ahead to so the one you just mentioned with the bloody nose incident,
Yeah.
Your Honor. The February 23rd, 2026 incident. Need to evaluate this and scrutinize this one as well. What the evidence actually shows, despite what he has alleged regarding this, what the evidence demonstrated to investigators, and which we think is more credible, is, again, he assaulted her, violently grabbing her by the shoulder and throwing her into the dashboard.
Okay.
I looked through his declaration from 2 days ago. I don't even think he acknowledges that his force sent her into the dashboard, but he acknowledges that in his written statement to police.
All right.
So he's having a hard time kind of keeping his story straight and providing some context for her injuries. He did, after that incident, he did finally drop her off at her house. He feared, and this is not me speculating, this is what's going on in his head according to his statements to police. He feared that he injured her. Shoot, maybe she has a bloody nose. And that's why he did not call 911, which I think is curious.
He didn't, but she didn't either.
Right, but what my point is, he's saying, I was about to call 911, but I thought I injured her, so I'm going to go to her house and see if I can contain this chaos, which I think implies guilt on his part. So he returns
How
to
long after the incident did she text him saying, there's blood coming from my nose? I think in that reference, though, he was asking for a sexual relationship. That's how
Sure.
that, preceding that comment that she had made about her nose.
I appreciate that the court was not saying that Dakota's text to Taylor are so DTF, not DTF. I appreciate that the court has mitigated that, but the court has all of these texts. So the court has read all of this stuff while sitting there looking at both of them.
Nose bleeding, right?
This was, as I understand it, in the immediate aftermath of that, so minutes after.
All right.
So not hours or days, very soon after.
Okay, all right.
Which I think is curious.
But she
Again,
took a photo of the arm, the bruise, but not the face that apparently was.
yeah, she should have. The bruising, she
I mean, that
thankfully,
would be seemingly more compelling, wouldn't it?
I mean, it would be nice to have it today, sure. But I mean, she got around to taking the photos after the bruises developed, and she should have taken a picture of the bloody nose.
Okay, all right.
And again, this is the instance where he claims that she just assaulted him, and yet he goes back and asks for sex. And we'd object as to foundation, as to these call logs. The call logs that have been submitted and evaluated are all over the place, difficult to follow in terms of the dates, the timestamps. Some of these communications.
So they are not the carrier records then. I'm interested about the carrier records because they have some carrier records, but not all. I got questions.
Show that these are outbound calls from Dakota to Taylor. Some are coming from Taylor to Dakota. And so we don't think that it actually lines up and demonstrates that there's 100 missed calls from her on one of these days. So we believe that these instances, among other
carrier
things,
records.
among his possessive behavior, which we've outlined with some examples in our exhibits, his vindictiveness.
Lyndon, I just have to take a moment to highlight this comment because Lyndon said, I can attest to the difficult to follow. I'm not following any of that. Also, there's another DTF. So some of you can go DTF difficult to follow. The rest of you can go DTF a la Jersey Shore, which is how I meant it. So Dakota could present his carrier records from his carrier because his carrier records would show all of the inbound calls to his phone. He could get those. And it sounds like he presented some, but not all of them.
In terms of trying to, again, go one step ahead of things and ruin her life with the leak. We think that this will be important to have a protective order entered for her. She'll certainly benefit from it, and she's met the grounds for doing so. Do have a couple comments on his protective order as well, Your Honor.
I think they will both benefit from a protective order. That's where I'm at with
again,
it.
she's trying to take accountability, and she has done so in this case, related to the Barstool, and
Can I ask
certainly.
a question about that too?
Sure.
Didn't she make those same arguments at the time of her criminal sentencing?
Yeah, I
Oh,
presume
boy.
I was not involved in that, so I don't know exactly which statements.
I bet the
what
court has
statements
the
she would have made.
transcripts.
All right, okay, all right.
But we believe the court has discretion, certainly, to enter a protective order in Dakota's favor, but it's not mandatory in this particular case. He has shown zero fear of my client whatsoever, which is an element. It's not a silver bullet. I don't know that there is a silver bullet, but it is a relevant element to consider here. You can see it in his expressions and how he communicates to her during even their most heated exchanges. He eggs her on, laughs in her face, insults her relentlessly. You can see this lack of fear in how he pursues her over and over again, love bombing her, manipulating her. Examples of these possessive overtures are included as exhibits B and K in what we've submitted to the court.
Mhm.
We can see this in how he's working overtime to completely destroy her. He is obsessed with this woman. He's not in fear of her. Those are different issues. Likewise, the court
Yeah,
can
the
and should
judges-
consider the passage of time of
The judge is not new to any of this. This is what this judge does.
many of these instances. The court understands that you are prevented from only relying on a passage of time, but we still think it's relevant in this particular case. If he was in fear, if he's truly been in fear, trapped in this violent relationship for over 3 years, if he truly considered himself a victim who needed protection, why would he instead just sit behind a camera and just stash embarrassing, difficult moments in their relationship? It's not really in line with what we'd expect, how we would expect a victim to act. And so we are asking
That's
for
not
entry
going to
of the
fly with
protective
this
order in her
judge,
favor
counsel.
and denial of Dakota's protective order, Your Honor.
Okay. I want to switch gears and go to the parent time issues. I want to start with the guardian ad litem.
Yeah, the court's like, yeah, moving on. Just moving on. Just moving on, counsel. We're going to hear from the guardian ad litem regarding parent time. Remember, parent time is something that, because Dakota filed first, was modified from their current child custody agreement. So they are trying to talk about when parent time is going to shift and if it will shift. Because at one point, parent time had been 50-50. At one point, it had been 70-30 with her having 70% of the parent time. And then when Dakota filed the protective order, he requested 100% parent time and got it. And then they modified it on the April 7th hearing. And when they modified the parent time, she now only has supervised parent time. So they are now having a discussion about parent time. We're going to hear from the guardian ad litem, who is looking out for the child's interest, not the father, not the mother. What keeps the child the safest? And that is where we're going from here.
And see where we go from there.
And Your Honor, I'll be pretty brief. Frankly, since we were here last time, my opinion and recommendation hasn't changed, and it's still based on the same argument.
The guardian ad litem is sitting down. I'm going to move our hearing notice because that's exactly where the guardian ad litem is sitting. You can see all the attorneys in the courtroom turned toward the seat where the guardian ad litem is, but I'm going to just move that so it's a little easier to see the guardian.
That I made previously. I've reviewed all of the new information. I tend to agree with the police report that as you read through everything and look at the evidence, it's difficult to find credibility with these February incidents from either party, frankly. My concern goes back to the initial incident in 2023 that
incident.
didn't involve my client, who wasn't born at the time, but did involve I guess I can't say petitioner or respondent because they're both petitioners and respondents.
Mother and father.
Mother and father is
correct.
easier.
But that incident was alarming to me because of the chair being thrown with the child sitting right there. I know it wasn't intentional it wasn't child abuse in my opinion. She wasn't intending to throw the chair at the child. She was intending to throw the chair.
Direct child abuse, but it
It-
certainly was domestic violence in
They-
the presence of a child.
Correct. And they charged it as reckless child abuse,
Right,
but
right.
it also, that got dismissed as part of the plea deal. Nonetheless, when you read through the probable cause statement, it's a concern. I mean, they're fighting, the child's sitting right there. You know, domestic violence related child abuse can be a little bit interesting in that sometimes you might have a child in the room next door, but the child's not in like direct harm. In this situation, the child wasn't in direct harm. The child was sitting right there. The chair hit the child in the head. And that didn't, like, that didn't stop her. It didn't stop her actions. Again, she pled to the charge. She did the DV assessment as part of her probation. She's complied with probation. She completed, from what I can tell from the probation report, everything that she should have, and she should have learned from that. And then we go back to this May incident,
Right.
and I understand, and I said this last time, there's a beginning that's not filmed and there's an ending that's not filmed. But what is filmed is Mr. Mortensen holding his son and Miss Paul coming at him and pushing him and pushing him. And I don't think it's the trip incident that has been discussed, because it sounds like that happened after the camera was off. But you can see Mr. Mortensen, you can see the camera go like this, and then it kind of ends. It's clear to me, I mean, that was, again, putting my client at risk of physical harm. If this was a situation where the the domestic violence and the fights.
And the reason he's referring to the May 2025 incident as my client is because his client is Ever, the child between Taylor and Dakota. And the only reason I'm using the child's name, A, it has been used on television in this show, and B, they have used it here in court. Otherwise, I would just use child. But the reason that that's different for those of you that have not followed this case at all from the 2023 incident, the 2023 incident where Taylor is throwing metal bar stools at Dakota, her child from a prior marriage is on the couch sitting there. Dakota's filming that incident. That's the video they were talking about earlier. That's the video they were talking about leaking to TMZ. So the concern of the guardian ad litem is the concern that the guardian ad litem brought up last time, is that she had the opportunity to go through a diversion program and do parenting classes, domestic violence classes. She went through the court's program, and then there are still these incidents happening. And that was the guardian ad litem's concern the last time, is that the child being immediately present does not stop a violent reaction. That was his concern about the incident with the barstool. That is his concern about the May incident that Dakota's recording, is that even though Dakota is holding the child, she is still going after Dakota. And that is what the guardian ad litem's concern has been since the last time and continues to be. And it's interesting to hear that the guardian says, I agree with how the prosecutors assessed the February incident, is that neither are credible historians of what happened in that incident. And so the court is going to look to the guardian ad litem first and then to the parties second. And I understand those concerns. If you've already gone through all the court programs in the hopes that there is a different outcome and the outcomes continue to be the same, then what are we doing? And so that's where the guardian ad litem has concerns, understandably so.
That had occurred were done in the presence of the child, and the child wasn't specifically in physical risk, or if there was kind of a wake up when these things happened and it stopped. I might not be recommending supervised parent time, but I am really concerned about, like I said last time, Ms. Paul's ability to control her behaviors in these situations.
Well, I mean, this is the question I have for you,
Yeah.
which is I don't see really that there's any other, let's say no criminal matters I could find regarding Dakota. And the only criminal matters that were found had to do with the interactions that they had with each other. And even in the videos too, as well, the injuries, these are all relative to interactions the two of them are having with each other. What's the risk in terms of to the children if I'm keeping them both away from each other?
I think the risk is
That's
that
a
when
fair
you have
question.
someone who perpetrates domestic violence or is involved in domestic violence, and there's no sort of learning to control the behavior, I think the risk is that there can be future relationships with other people, that those relationships can lead to domestic violence again. I think that there can be additional fights that happen with other people, but I agree, there's no criminal history there. It's just those two situations were extraordinarily concerning to me because there wasn't that sort of wake-up call when the child was put in harm's way. And again, it's my concern that there's a lack of control there. My thought is that the family is working with the division. They're doing services with the division.
What happened with the case closure on the DCFS investigation?
Supported mom for DVRCA and supported dad for failure to protect.
Oh, they both were supported.
Correct. One for failure to protect, the other one for DVRCA.
Okay.
So the division is providing services to
They're talking about the Division of Children and Family Services providing support or services to both parents. And you saw the commissioner respond to that. They were providing services to both. Yes, as to Dakota, failure to protect, meaning failure to remove the child from the anger and the situation with Taylor Frankie Paul, and Taylor Frankie Paul for DV in the presence of a child. So as to both of them.
The family. What I would like
Now?
to, yeah. What I would like to do, and I understand that the court has the primary custody case also. And so, maybe this isn't the best idea in the world, but what I would like to do is set a review date and come back in about 60 days and see what the progress is on the DCFS cases.
Do
And
we know what services are being,
I
what they're
do,
doing right now as part of a services plan?
I do, I'm a little bit hesitant to discuss it on the record. But there's going to be some assessments done by both parents and then follow the recommendations of those assessments.
TV assessments?
Yes, and mental health assessments.
Okay. So this is not voluntary. It's
At this point, it's
avoid filing of a child welfare petition.
that's essentially it. So I think that they would call it voluntary because there's not court orders. But I think that there has been discussion of filing child welfare petitions, but for the agreement to do the services.
Well, this isn't juvenile court. I can't take the kids away
Correct.
from both, child away from both of them. And
Correct.
supervise them both, right?
Correct.
But what I think I hear you saying is you're more concerned about her conduct than his, though. I mean, any concern about what you've heard with respect
what
to
he
his
said.
conduct?
I
And,
agree. That's
yeah,
what
I mean, absent her behavior, I mean, there's certainly,
the guardian ad litem is more concerned about her behavior because her behavior does not cease when the child is around. That is why the GAL is more concerned about her behavior. What the court was asking is, are we concerned about her behavior if the two of them are not interacting together? Because there's no allegations of any instances that don't involve the two of them. And that's what the court is asking about now and asking a bit more about now. But it sounds like the reason that DCFS isn't pursuing court-ordered petitions is because both parties are willing to participate with services.
under certain circumstances, I might consider supervising him as well.
And I understand that too. My biggest concern, well, I'm not going to sit here and say I don't have concerns with his conduct. I mean, I've listened to the audio, I've watched the video. I don't understand from his position how when he's being attacked, rather than booking it out of there, which would probably end things, he pulls out a camera and films it.
Well, I had those same thoughts.
Yeah, that is a concern for me. But his actions, as I see it, he's not throwing chairs that are potentially hitting my client.
Right.
He's
a difference.
holding my client and backing up when he's getting pushed.
There's
are
the difference. I have some thoughts about that too, about the nature of each of their behavior.
Yeah. With that said, I mean, I don't disagree. I mean, it's 2 years that my child.
Right. And now the court and the guardian ad litem are sitting there as the adults in the room saying, how do we protect this child? How do we protect this child when these parents are acting this way? Because we have concerns about their behavior. And the court is saying, I have concerns about both parties' behavior. So what do we do to get these parties to stop behaving that way? And if these parties are not able to stop behaving that way, then how do we move forward so that the child is safe when the child is with both or each parent, which is probably going to be a third party doing custody exchanges and them staying away from each other, period. Which seems to be the way I think the court is leaning at the moment.
That my client has been alive, basically,
Mm-hmm.
and he's been exposed to this for that 2 years over and over and over. And Mr. Mortensen has an issue. I mean, that's why they supported him for failure to protect.
Yeah. Okay. All right. Let's go. We'll go back to Mr. Hall. You'll be up next on the parent time issues.
Okay, so this
Well,
is
Your Honor,
Dakota's attorney on the parent
that's
time
why-
issues. And again, currently as it stands, there is a custody case. And right now, Dakota has primary custody, which is different than the custody case. And Taylor Frankie Paul only has supervised visits.
And I do take issue with it continually saying that Dakota isn't taking, or Mr. Mortensen isn't taking responsibility.
Counsel.
That's the responsibility he's taking. He believes he needs to break this cycle of continuing to essentially fail to protect by not withholding, not saying, no, we're not going to come back. I'm not going to take your text messages again. I'm not going to expose my
Well,
child.
he could have done that way.
He could have.
But he chose instead to file for a protective order.
That was his method of saying, I'm done and we're over and we're going to separate. And I think
Right.
that's a good way to do it. And we shouldn't blame people for filing protective orders to assist them with that.
Well, your argument, though, was that hers was, in a sense, retaliatory, but
I think there's a
there's some
component to
evidence
it.
there that, in terms of her bruising
And,
as
and-
well, passage of time. In one sense, you're arguing we shouldn't be dismissing his request due to the passage of time, but you were suggesting maybe I should with respect to her.
No, here's the most recent thing. We're saying it's just not credible. It doesn't rise to the level of
Right.
domestic violence or abuse, Your Honor, what she is saying he's done to her. He's trying to defend himself and leave. We have ample evidence presented that she has committed domestic violence and abused him. So we only need one protective order to keep this running. And his is to protect, we only need one to separate the two and do this. If he violates the terms of the protective order, I know it's not a criminal violation, then she can say, well, you're back here again. And trust me, the division won't like that either. But in terms of custody, Your Honor, I think what's really, I've got to cite CCW. And CCW does state, which I think is really important, to emphasize that even when there is no evidence of violence towards children, it is appropriate to completely separate it is inappropriate to completely separate or compartmentalize a parent's history of domestic violence towards other adults from the best interest inquiry regarding the parent's child. Such compartmentalization conflicts with the statutory view that a history of violent behavior has relevance, especially when committed against the other parent of the child. Both common sense and expert opinion indicate that a parent's act of domestic violence can have adverse effects on a child, even if the child is not the direct object of such violence, and even if the
Right.
child does not directly witness the violence. You've heard conflicting testimony. I know you have to make a call, Your Honor, in terms of credibility, but the one thing that's run throughout this entire case of all the evidence you've seen is we have multiple incidences of domestic violence being perpetrated by Ms. Paul against my client. We have only one incident that she's claiming of him injuring her, besides the one that both parties the police are saying are incredible, where it's seen and it's seen on the video, it's defensive. And I think that lowers the
I don't think
credibility
the
of it,
court
makes it that we don't need
agrees.
it.
I really don't think the court agrees with exactly what Dakota's attorney is arguing at all. You can see the court's face in that.
We don't need her protective order. We don't want to put them on kind of the equal footing here. We need to call out who's the abuser and who's the one that's failing to protect from the abuser
And that's
in the
his
past,
argument.
and he's trying to protect today. I did want to mention, there's some text message I submitted. I think it's Exhibit 5 in my rebuttal, where she says he's a good man. And she apologizes for her behavior. But this is 2024, and it's still happening. Also, I know we have siblings in this case. There's two older siblings that Miss Paul has with Mr. Paul. And what I did want to let the court.
They entered into an agreement as well, and she was, I believe, going to undertake some was it alcohol counseling or
Yeah, I'm not Mr. Paul's attorney, so I haven't really gotten into that, but I do believe you're
working
correct, Your Honor.
back towards 50-50.
The only point that I wanted to mention is that my client has already contacted Mr. Paul, and they've worked it out so that they will be able to make sure that the siblings have contact, even if my client is the primary custodian, because he can take the kids over to Mr. Paul's. And spend
Mr.
time.
They're talking about Taylor's ex-husband, the father of the older two children, the half siblings of the child that they are discussing in court.
Swinard, did she have equal custody of her other two kids? Okay.
Yes, it's 50-50. She and Mr. Paul were married for 7 years. They have a good working relationship, good co-parenting relationship.
Okay.
And then my final request, and I just wanted to say,
So what do you want me to do?
I want you to enter the protective order that we filed. I want you to deny her protective order. I want you to follow the guardian ad litem's recommendations in terms of parent time, set a review. We come back, we deal with it. We have the other case, which your honor holds.
Is part of this kind of a review right now?
Yes.
I mean, or maybe we're just waiting for more information
No.
from
DCFS.
DCFS and the
But-
services.
But I think we should have that review to do it.
I mean, this is part of
I
the
also
review.
think, your honor, I mean, I'll just put it out there. I'm happy to file the motion if you want to give me time, but
The court said this was a 2-week arrangement when the arrangement was made last time, and they were going to evaluate it now, which is why they're evaluating it now. But if they're going to have another 60, 90, 120 days out, then they're going to want to talk about what that arrangement looks like.
what?
there was a stipulation filed. There was a final order submitted that was declined to sign. She's now
Right.
filed new
Should
financial.
never reduced to a decree.
I just want to make sure that we don't have the immediate refiling of new documents. I would probably, if this court needs me to,
I mean,
file a
that's
motion to
fair.
set aside the stipulation to readdress custody matters, as we have very many
I'm
changes.
not going to tell you how to strategize, but
I just want to give me leave to do so in the event that happens. So that's-
I don't think that there's anything stopping you from filing a motion to set aside the stipulation that was reached.
Totally fine, Your Honor. I just want
Honestly,
2 weeks
I've
to
been
do it so that I
anticipating
don't
it.
have to do it
Yeah.
immediately and over that. That was all. So just 2
Okay.
weeks leave in case they decide to file tomorrow, the
All right.
final documents. But I think that's where it is. Does the court have any questions for me?
No, none further, except as far as reviews go, I think, Mr. McDonald, you were suggesting that we do that in this case. I don't have a guardian ad litem on board in the domestic matter.
My suggestion was to do it in this case, and just, this might be helpful information.
The court is asking the guardian ad litem if they're doing a review in the protective order case because there is not a guardian ad litem appointed in the, and when he says domestic case, he means the custody case. I mean, he means the domestic case. I'm translating it because when we're talking about domestic violence in this case, the domestic case can sound like something different. That's the custody case. And there's no GAL in the custody case. I appreciate the court's mindfulness in saying, hey, if you want to review with the guardian ad litem that's appointed in this case, we keep that under this umbrella instead of the other case number to keep the GAL in the loop, which I think I'm interpreting is the court's preference. And I agree with the court on that.
Related to that, my understanding is that the parents are supposed to be getting those assessments done. I think DCFS has given them a deadline of May 27th, but those assessments could get done sooner. But that gives you kind of an idea of where things are.
But there's no, you said you were reluctant to say on the record what the services plan was. I'd be interested in knowing what that was.
So what I'll tell you is
But
that
it is. Yeah.
what DCFS is asking the parents to do is a DV assessment and mental health assessments, and then follow the recommendations. So that's sort of what the plan is going to be. We don't know what those recommendations are because the assessments haven't
We
been
know
done
how
yet.
far along they are in that process. So when we'll get those
I don't think it's deeply controversial that they are asking both parties to undertake DV assessments and mental health assessments at this point. It's just fairly normal that that's what we would expect.
assessment reports back.
So again, the first step is having the assessments done, and DCFS has given them a deadline of May 27th.
May 27th. That's a while out. Okay.
They could get them sooner. That's sort of DCFS's.
Excuse me, Your Honor, that's not a while out because it's gonna be May. There, that one was timely.
At least from my conversations with the caseworker,
All right.
that's what's supposed to happen. And if it doesn't happen, then I assume DCFS can't always file juvenile court petition.
Okay. All right. All right. Anything else before? I go
But
to
that
Mr.
becomes a
Sweeney?
mess too.
That's it, Your Honor. Thank you.
Oh, okay. All right.
Okay. And now on the parent time issue, we are going to hear from Taylor's attorney. And she is toppled over sideways. But the judge is just like, and this is what we're doing.
One point on the protective order, Your Honor, because it's been requested that been requested by counsel that a protective order is entered against Taylor, not Dakota, because Dakota doesn't need one against him. I do feel, again, setting aside all the domestic violence claims that my client has made against Mr. Mortensen and going to that question of need, does she really need a protective order from him? Does he need to have one entered against him? If we just look at this cycle and how long it's been followed by these parties over and over again, falling into old routines, bad patterns from both of them, frankly, there certainly is.
And this right here, folks, is a great indicator of giving your client something to do. Look, there's times where we look at clients and we're like, what are they writing over there? I would rather her be taking notes if I'm her lawyer than sitting over half sideways. I would rather her be taking notes or sitting with her hands together or whatever than this. And that is part of the reason I think that they give a lot of defendants pen and paper, sit there and take notes. Because when you sit there and take notes, you're not doing all that. Because it does not look good. And it does not matter if you are uncomfortable, if you are having a hard time focusing, whatever it is, you have to control your demeanor in court, no matter how hard that is. Get a piece of paper, get a pen, and take notes. Or doodle. I don't care what it is. Do something to keep your hands on the table and keep your bodies there. But anyway, that's just my thoughts. So continuing on.
And how long it's been followed by these parties over and over again, falling into old routines, bad patterns from both of them, frankly. There certainly is a risk that if he's not ordered to stay away from my client and not communicate with her, if there is not a protective order in place, there's certainly a risk that he's going to fall back to his old ways. So that is, among other reasons, why a protective order should enter.
All right.
On custody, I'm happy to address that now if you'd like, Your Honor. On custody, you asked,
you're
what's
here
the
to talk
vision
about
for this
custody.
case from here?
That's the point.
Depending on how we handle it, we could either get some resolution, some movement, and restoration of custody, or we could just go into an infinite review hearing death spiral, which I don't know if anyone's particularly interested in. It has been very difficult for my client to come up with words to describe how she's been affected by being cut off from ever over the last 6 weeks. And for the first 3 weeks, it was completely cut off. And then the court somewhat relaxed it beginning on April 7th. Again, that's at Dakota's request, the initial suspension. As the court already knows, this has been a huge break from the status quo that they've been following since Ever's birth. She shares custody of Ever's 2 other children, which the court has already...
Not Evers, Mr. Paul.
Yeah, that's correct. She shares custody of Ever's 2 older siblings. Taylor and the 3 kids are accustomed to sharing a bunch of time together, and that's been taken away from them almost entirely. In our declaration that was submitted yesterday...
How far apart in age is Ever from the elder
they're
2 children?
close.
Yeah, 8, 5.
8 and 5.
Okay.
So they're pretty
All
close. They're bunched in together. They like to spend time together. Most of our declaration that we submitted yesterday was devoted to this normalization of custody of Ever. He is a happy and healthy kid. Hope he can stay that way. Obviously, there's some things we need to address here. My client pointed out in her declaration yesterday that she makes it a huge priority in her home to keep these kids off of screens, doing interesting things like art, playing outside, visiting fun places together as a family. It's been remarked by Tara Almond as well as Aspen May, the 2 supervisors in the case, that Taylor shows a lot of patience with the kids. Her harshest form of...
This is part of the reason why I was asking, why, maybe you should consider whether we should have had a paid supervision service observing so I could get a report from someone who's non-biased. In other words, not her sister or her friends or family members who were conducting the supervision, whose declarations, they're kind of inherently biased. They may be truthful, but they're inherently biased, as opposed to somebody from the outside. That might have been a little bit helpful for me as well, as in terms of how the kids were responding when mom showed up.
Sure.
Yeah.
I understand the concern, Your Honor, but bear in mind that multiple possible supervisors were suggested. 2 were vetted and selected.
Mhm.
And the part of the reason they were selected is because these supervisors, Ms. Almond and Ms. May, they have a great relationship with Dakota and Taylor. And I understand that on paper, they're more aligned with Taylor, but these are not
I think they
necessarily.
probably would have been more focused on their mom, but okay, the kids, yeah. All right. It turned out the way it did, and I wasn't going to
Understood.
force it, so. All right.
Okay.
Right.
So my client,
The court wanted a report from a neutral third party. Right.
she has the time, she has the network sufficient to continue caring forever. Her friends, her family members live here. Paid nannies live here. Dakota, we don't have a great sense of his availability to really be the full-time parent in this particular case, whether he's overly reliant on third parties. We know that he runs a small business. He rents a room in a home with a roommate named Crew, who apparently is here today.
Can I ask one more question too? We're going back to the parent time issue. This is what's more weighing on me right now. Is you had mentioned. I was really more concerned about what your client had gone through as part of her criminal probation in terms of classes, courses, etc.
Mhm.
And whether or not some of that might be. You said she hasn't been drinking at all. I mean, has she been taking random UAs, that sort of thing?
Yes.
Okay.
Oh, okay.
Yes.
All right.
So she just answered the court directly. He was asking the lawyer, not her. She answered anyway. You could hear her say yes. Because has she been taking random urinalysis? That's what the UA was, and not been drinking at all. And sorry, my back hurts in my chairs. I'm getting wiggly. But Emily, you said in court, I know. I'm not in court. They needed to talk to their client about how the judge perceives things. Either way, the court wants to know about what she is doing, including not drinking. And has she been taking random tests for that, and said yes. So, okay, maybe she hasn't been at all.
So that's something that she did on the criminal side, and as Mr. McDonald has reported to the court, that's part of the services that DCFS is presiding over right now. Both parents have been asked and are willingly going to participate in a domestic violence assessment as well as a mental health evaluation. As far as the custody case, the court already understands and has pointed out the strangeness of the fact that Dakota agreed to give my client custody only in August of last year. And I do have to correct the record. It is not a 50-50 agreement. It is approximately 70-30 agreement.
That's right. That's right.
In my client's favor.
Yeah.
So they followed this
thought
from the
it
date it
was
was signed. There were some exceptions for travel and work schedules.
70-30.
He never asked for supervision in the custody matter. By signing the agreement, it's obviously important for a variety of reasons. He gave custody of this child to Taylor only a few months ago. And I think that implies that he understands that she has skills, parental skills, parental fitness, and a very important bond with Ever. And he has an important bond, Ever has an important bond with Taylor, sufficient to justify giving her custody of this young child. So at the time he signed this, at the time Dakota signed the stipulation, he had a laundry list of problems with my client. In fact, the vast majority of the baggage of their relationship had accrued up to August 22nd, 2025.
This is pertinent to parent time now?
I think so, because again, it does go to
court-
what's going on.
The court's like, why are we relitigating stuff you've already told me? Parent time. Focus, counsel.
In his head. And so I'll get to my point right now, Your Honor. If he thought, this goes to the question of where is Taylor's anger directed? If Dakota thought that Taylor's anger could be directed at the children. If Dakota's not present, specifically ever, if Dakota's not present, he would not have signed this agreement giving her custody of Ever.
Well, let me ask Mr. Hall, just for 1 second here. You made reference to, I think, CCW.
That's correct, Your Honor.
Guidelines, that is.
That's
Can you
Court
elaborate on that a little
of
bit?
Appeals, State of Utah,
In Ray CCW?
NRA CCW 2019, our Court of Appeals.
Okay. And that was in the context of compartmentalization when we were talking about violence towards,
The court's asking for the case law.
Anti-compartmentalization. We should not compartmentalize. That's the ruling from our Court of
do you have the
Appeals.
side on that?
I do, Your Honor. It's 2019 Utah App 34. If you'd like the Pacific Reporter, I can give you that one as well.
Please.
440P,
Okay.
3rd, 749.
All right.
And the specific spots that I quoted,
And now we all have our
That's okay.
sites.
If I read it, I'm reading the whole case.
page 19.
Fair.
All right.
And so the court's
All right, you can
asking
keep
for
going.
a cite on the
Thanks.
case
I only
law
need
from the other
another moment,
party.
Your Honor.
Okay.
This court observed, I think correctly, that her anger, her outbursts are only directed at Mr. Mortensen. Mr. McDonald echoed this observation on April 7th. He noted that it's not directed at the kids. There has been speculation by our guardian ad litem that there's a lack of self-control which could negatively impact the other children if there were outbursts at other people, including the kids. Now, I understand as the child's advocate here why he would make this comment, but there is no evidence to support this. The only evidence shows that it's a Taylor-Dakota problem, that her outbursts and anger are a Taylor-Dakota
I
problem.
still have to factor it in under the statute, right? Domestic violence is the number one factor now when it comes to making custody and parent time determinations.
You factor it in, and it's also highly relevant that there are mutual allegations in this case.
That's right. There are mutual allegations.
Both parties have made multiple representations that we have a toxic cycle in this relationship, and it supports the argument that, again, it is a Taylor-Dakota problem. He admits our relationship was terrible over and over again, toxic over and over again. I think this next point is important, Your Honor. If there's a concern that unsupervised normal custody, so a 70-30 unsupervised arrangement, could subject the children to outbursts, that is hypothetical, and that has not been proven based on the evidence thus far. On the other hand, the harm being experienced by my client, by Ever, by the two other children right now, is not hypothetical, it's real. It happens every time during these exchanges, and during every visit, every day that they're prevented from having a normal amount of time with each other. These visits are extremely disruptive to this child.
Well, are you saying I shouldn't be concerned by the behaviors towards Dakota in terms of, you're saying there's no way that would happen in another stressful situation that she might encounter?
Correct.
Tread
She's
carefully,
uniquely
counsel.
patient with the children. And Dakota
Well,
is
not
uniquely...
entirely, because at least not when the two of them are together in the same
That's
place
what I
at the
mean.
same time. Yeah.
So Taylor and Dakota, they're the common denominator here. That relationship, hallelujah, is dead and gone forever, and everybody will
What?
win as a result
I don't
of
know
that.
about that. I don't know if that relationship's dead and gone forever.
Yeah, the court calls BS on that. The court calls BS on that. The court calls BS on that. With the hallelujah. What is happening in court today? Okay. The court's like, yeah, I don't. If you were listening in the background, come back and watch the judge's face. Come back and watch the judge's face. He's not having it at all.
Be concerned by the behaviors towards Dakota in terms of, you're saying there's no way that would happen in another stressful situation that she might encounter?
Correct. She's uniquely patient with the children. And Dakota
Well,
is
not
uniquely...
entirely, because at least not when the two of them are together in the same
That's
place
what I
at
mean.
the same time. Yeah.
So Taylor and Dakota, they're the common denominator here. That relationship, hallelujah, is dead and gone forever, and everybody will win as a result
I don't
of
know
that.
about that. I don't know if that relationship's dead and gone forever.
If the court
Part of
enters...
my that's part of what my thought process is
Sure.
as we're going on, as I'm
Well,
contemplating.
we anticipate a protective
Mhm.
order being entered today, which will be the final nail in the coffin. Obviously, we hope that there will be
Okay,
a
counsel.
co-parenting relationship that can form and
Well, I
and
agree with that.
improve.
Yeah, yeah. I mean,
Um,
that has to happen. I mean,
Yeah.
I'll have some things to say about that too.
A couple of just updates from our perspective regarding DCFS, then I'm done, Your Honor. Both parties are engaged in voluntary services. The next meeting that my client has with the caseworker, Hiram, is tomorrow. The safety plan is being implemented. I don't know any details beyond what Mr. McDonald has already said. I expect those shortly. And so my office,
Sure. Didn't the parties receive copies of the safety plan?
I think that's forthcoming. And right now, we just have the initial.
They usually sign off on it.
You signed safety plan? No, my understanding from what Hiram has told me, the caseworker, is that that will be entered into tomorrow.
All
He's
right.
meeting with her tomorrow.
When was the case closure on this? When did the report?
I don't
come out?
have the exact date, but CPS closed their case, I would say, it was shortly after we were here last time, around,
And I never got the written report. All right.
I don't know if they would have, Your Honor, I think that they generally only submit written reports if there's physical abuse that's alleged.
I see. Okay, all right, okay.
Couple more
That was
points,
the
Your Honor.
guardian ad
Both
litem
parties have been asked to
adding
do the
information.
assessments. Neither has started this. My client, we got from the caseworker today a referral, and so we're going to be reaching out and getting that underway.
Okay.
Also, she already has made, and they have already made some adjustments that are helping the situation. She's trying to take accountability and move on. She has been
In
working.
what way?
She's been working with a therapist. She'll continue to do so.
I don't have anything from the therapist yet.
That's
right?
correct.
Okay.
I
And
appreciate
what's
the court.
Is there,
I appreciate that the court's like, how? What are you doing and how are you doing it?
DV component to the therapeutic intervention here?
Can I ask my client, Your Honor? It's a big theme in the therapy. They're going over it, talking
Right.
about it.
Okay, all right.
We don't know if Mr. Mortensen is. From the tone of his filings, my guess is he is not undergoing therapy.
What?
Very importantly, Your Honor, party communications.
What do you
So
mean from the tone
messages
of the
between Dakota and
violence?
Taylor have stopped entirely. She stopped the
That's good.
communications long before he filed the protective order.
Well, there has to be some means of communication. They have a child.
Using a third
involved.
party right now.
Yeah, okay, good.
Now, one thing you'll have to grapple with today is institution of our family wizard. My client thinks it'd be a good idea. If and when they resume those parenting communications, this might be a situation where we continue to use a third party for the time being
Yes.
and then revert and then
Yes. 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 You need a third party. Yes. 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 You need a third party.
switch to our family wizard. Think continuation of using neutral location for exchanges would be helpful. Using third parties to facilitate exchanges would be
Yes.
helpful. This has been voluntary, Your Honor. I mean, her working with DCFS, her accepting feedback from law enforcement in terms of how to get make some adjustments to create some distance from Dakota. These have been voluntary adjustments that she's made. Some people completely disregard what DCFS requests, what input law enforcement might provide. But this is something that she's taking to heart.
Well, everyone says that they'll be in compliance. Time will tell, right?
Yeah, exactly. I understand. So at this point, again, we are asking for rescue.
A lot of you are asking about Our Family Wizard. It's an app that you can use for co-parenting and custody exchanges to communicate. I believe that there is a component of the app where the communications within the app can be sent to the court. Like it logs them so both parties have representations of what's happening within the app. And then you are not texting each other, hopefully, and all communications stay within the app where the court has access to it. And so it is not manipulable like text messages, and the court can see what's happening.
Of that custody arrangement that they agreed to in August. I'll just close with saying these visits, the back and forth, the abrupt end to these short exchanges with Ever and Taylor are excruciating for both Taylor, Ever, and these two other kiddos,
I just don't have an independent report. I think that's your client reporting to you, right?
as well as the supervisors. But also, I think it's a pretty reasonable assumption to make that a 2-year-old child seeing his custodial parent after 3 weeks absence
I don't
is
know.
going through a lot of confusion right now.
Different kids are different. Some are more resilient, some are more adaptive, but yeah, I understand what you're saying.
Yeah, understood. Thank you.
And I do have to address that speculation council made. My client is seeing a therapist.
He is?
He
Okay.
is.
All right.
Good.
Well, let me go ahead and make some recommendations.
Good. Everyone should be in therapy. The therapist should be able to report back to the court. That can be sealed. That doesn't need to be public. Nobody's business, but the court should know. Using a third party who is a neutral, non-family member third party who can also report back to the court would be good. Also, having these parties away from each other is 100% what's needed. Because from everything we have seen, the issues between Taylor Frankie Paul and her ex-husband was the improperly communicated boundaries with regard to opening their relationship to other parties. It wasn't this. This was not the issue. So we will see what happens with the court's recommendations. I'm interested to see what the court says. I expect that we will see parenting recommendations first. Maybe we'll see what the court thinks about the protective orders now, maybe not. So we'll see. But I guess we'll see. All right. Wine Yogi said, I was going to say what happened with the ex. There was a swinging scandal. Yeah, there was a swinging scandal. So they have seemed to have gotten along, and he has indicated in the media that he was surprised by the behavior between Taylor and Dakota because that was not his experience. And I think he was incredibly displeased that the video came out when he had never seen it. It's not like Dakota went to Taylor's ex-husband and said, hey, shit got really hectic and your kid was there. I think you need to know this. The ex didn't have any idea what was in that video until TMZ had it. So I know Dakota's lawyer is also like, well, no, Dakota's going to talk with the ex-husband and make sure that the kids all see each other, which is great. But it's not like he wasn't looped in, or it's not like he was looped in when the harm was happening and the kids were there. So I have questions as well. All right. So continuing, I'm curious to see what the court says.
But I may defer other portions of this. And I have to be honest, I've struggled far more with the parent time aspect of this than the protective order aspect of it. I think.
Okay, just kidding. The court is just like, get the fuck away from each other. I don't know how to help you guys parent better, but I know you need to stay away. I know you need to stay away from each other. I know you do.
I defer other portions of this. And I have to be honest, I've struggled far more with the parent time aspect of this than the protective order aspect of it. I think there's been, let me just address first this notion of passage of time and filing later on. The statute's pretty clear about that in the sense of passage of time alone not being a basis for denial of a request for a protective order. And I've seen this come up in multiple cases. And typically when I look at that language and I look at the cases where I've seen requests for entry of orders long after the incident occurred, it would be something in the nature perhaps of the context where there was an incident that led to criminal charges being filed. Somebody goes to prison. There's a protective order perhaps out of the criminal case that's in play. And then years later, they're being released. And now the request for the protective order comes in because of the because now that level of fear comes back to the surface as the perpetrator is being released from prison. I do have some issues when we talk about lapse of time and whether or not it's okay just to say, okay, I'll just hold on to that and use it when I need it. When custody issues may arise, for example, years later, I'll go ahead and make my request for the protective order, knowing that there's this passage of time provision, and use that down the road. And I have a problem with that. But when I thought about it in this case, my part of what I thought was, well, if that was the case, there was a stipulation for equal parent, or excuse me, there was a stipulation for parent time, really, that effectively would have resulted in Taylor having the majority of the time. So if he was going to do that, there was certainly plenty there for him to do it before the stipulation
point.
was entered into, meaning that he knew about the incident in 2023, the incident in 2025 had occurred,
Most of the incidents
and
had
then
occurred
the
when they made
stipulation
that.
came after, and then after that, it's when the protective order was filed. So I don't necessarily think that was a primary motivating factor for him, at least to gain a leg up in a custody dispute, because I think he could have done that a long time before. That's not to say that I don't have some problems with the reasons why this was filed, or that I don't have some concerns about his conduct too.
Right.
Both counsel referred to it. This has been a very toxic relationship. It's beyond the pale in a lot of ways, the toxicity here. And I've had some thoughts about this, about what's this dynamic that we're seeing here. And
A domestic violence cycle. I'm also trying not to sing toxicity. I'm very much trying to not sing toxicity because it helps no one at this moment. But yeah, what is this cycle we're seeing? The cycle of domestic violence, Your Honor. Yes, that's what we are seeing. He's like, this is appalling behavior. Yes, agreed. Agreed, Your Honor. Okay, let's see what he has to say.
It's beyond the pale in a lot of ways, the toxicity here. And I've had some thoughts about this, about what's this dynamic that we're seeing here. And I think that what I've seen from the evidence, even post last hearing, some of it was before the last hearing, some of it was after, was in some ways there seems to be a continuing attraction that they have for each other, whether it's physical, whether it's the thrill of the two of them, being a part of making themselves celebrities. There seems to be this attraction that they continue to have for each other. Each of them have been texting each other, wanting to get together for physical relationship, to continue on to the physical relationship. In some cases,
he has had to read all the texts. He has had to read the texts. Yep. We're going to move quickly from System of a Down to Britney Spears in a moment. Emily, don't make light. Look, the court has had to read all of their text. I'm making light on his behalf. But yes, this is exactly what this judge does all the time in family court. This is a regular part of this court's work. So, yeah, he's just like, okay.
She's invited him over. He said okay. In other cases, he wants to come over, and she lets him in. And the problem is that the two of them can't be together in the same place at the same time for very long before it starts to turn violent. And that's part of the problem. That I am very concerned. And I think I just have to say it. This is not anything that I don't say in a lot of other cases, which is that you guys have to figure out a lot here.
Yeah.
You have to figure out how to function as co-parents. This has been dysfunctional. This is a lifelong proposition between the two of you. You're going to be.
You have a child. Stop it. I appreciate the judge, but this judge has to do this day in and day out. And part of it is going to be telling people this is a wake-up call. Wake up. Wake up. Yeah, wake up. And knock it off. Because the judge wants better for the children, of course. But the judge also doesn't want this case to become a criminal case. This is an intervention, hopefully before they end up with more criminal cases, which is something that family law judges are thinking about. They do not want this to be another criminal case between these two parties. They want them to both get the help they need, get the support they need, and be better for their parents. Be better for their children, be better parents for their child. This is why we don't stream late at night. So, all right. I'm backing it up so I can let him finish his thought.
That you guys have to figure out a lot here. You have to figure out how to function as co-parents. This has been dysfunctional. This is a lifelong proposition between the two of you. You're going to be, you're linked together for the remainder of your lives. You're going to be the grandparents of the same grandkids someday. You'll be at their same graduations, their same weddings. You're modeling right now how you deal with conflict to a 2-year-old. This can affect this child on when the child grows up and becomes an adult and is.
Use your words. Yeah, you're trying to model that to a 2-year-old.
And in his own personal relationships as well. When we talk about cycles, this is part of your legacy. This is the legacy of violence being passed on from perhaps generation to generation. I don't know. I'm not familiar with your childhoods.
Wow.
But it's certainly concerning all the way around. Meanwhile, I have to make some decisions about, because you couldn't come to agreement as between yourselves, I have to make some decisions about not only entry of orders, but then on top of that, if not here, then in the domestic case as well, about what your parent time arrangement is going to look like, at least for the short term at this moment. I think there's some merit to both of their arguments about their bases for protective orders. I certainly think it's an easier call with respect to Dakota's request for a protective order.
Wow.
The video evidence is really overwhelming. And in terms of the elements that go into that give rise to the basis for the entry of a protective order. At the same time, I think there's also evidence, and I'm finding, at least with respect to the May of 2025 incident, that while the bruising, the injuries that Taylor suffered, it's certainly possible that some of these injuries could have been the product of self-defense, but I'm not finding that it's probable. I'm finding that there's been violence that's occurred both ways between these parties. Now, the difference, I think, is that with Taylor, is that her conduct is more reactive. That Dakota knows, and I think that she had indicated this in her paperwork as well, is that he knows how to, and I alluded to it at the first hearing a little bit as well.
He did.
Knows what to do to get under her skin, so to speak. And she reacts. She gives him the reaction that I don't know if he's necessarily looking for it, but she certainly gives the reaction. I'm certainly a little bit, I take some issue with his representations, with Dakota's representations, that his entire motive behind all this was simply to break the violence, the cycle of violence. I think first of all, there's a little bit of conflation between when the parties refer to the cycle. Certainly there's been a recurrence of incidences between this party, but it's not necessarily, and maybe in some respects it is, when we're talking about the cycle of domestic violence. All right, an incident occurs. Then there's sorrow, apologetic, promises to make changes. Then there's this honeymoon period, where they're trying to work things out. Then the tension builds again. There's another incident, and then it's all happens again. I'm just not necessarily persuaded that all of this had to do with child protection. I think some of it was, but I'm not sure that all of it was, because when I reviewed some of these videos that were taken by him, and quite frankly, this is I haven't really seen a case where the video evidence was of such a degree that I'm seeing in this case, where there's this where it's handheld type video that during the incident, as opposed to it being, say, a Ring camera that might have been
right, because he's 6 foot whatever, and she is not. So he can hold a camera away from her and film out of her reach, and she cannot. So yes, I'm not surprised that the judge has said, I've never seen video like this, because it is unusual, incredibly unusual.
in the room that's recording everything that's going on at all times, where we could maybe go back and look at the whole thing. This is handheld stuff. So he's got this child, for example, in the May 2025, the earlier part of that, I believe it was May of 2025, where he's holding the child in his arms. She's attacking him. I didn't view the video as him trying to leave and get the child out of there. I viewed him as him standing there being more interested in whether this video recording, he's looking into the camera in some instances, I think in a couple of these videos. One where I think somebody else was filming him while he's sitting in a truck and he's on the phone with Taylor. And so I think part of that is, a greater concern about preservation of evidence than it was about removing the child from the situation, which I think is borne out by the fact that he was supported as well by the DCFS for failure to protect.
Which makes sense.
So that's so as far as Taylor goes, I mean, I think the nature of her conduct is really reactive, and the kind of this inability to control emotions. I think his conduct really is more, well, how shall we say, give me 1 second here.
Oh, he is trying to find the right word. Interesting. Oh, that's a long pause.
I think it's more deliberative. I think in the sense of,
so hers
subtle.
is reactive and his is deliberate.
Maybe is one way to put it. I think that there is some manipulation. I do think that there is some obsession. I think there may be obsession that they may have with each other as well. But certainly I have some issues when I see
instigating
the photographs of the evidence that he asserts it's more probable occurred through was the result of self-defense. I don't feel that's necessarily the case. I think it's more probable that he caused these injuries to Taylor, and I do think she's met her burden as well. And I do think it's important that there be mutual orders as well. They need to stay away from each other.
Agreed, Your Honor. Agreed. I agree. There needs to be orders to get both of them to stay away so that neither one can try to game those orders against the other one. Right. It sounds like he's just going to go ahead and order mutual orders now. Like ruling from the bench. I'm surprised. I didn't think he was going to do that. I'm actually surprised. We've seen some really good judges in Utah. I appreciate the judges just like, no, we're not doing this. And I have seen this story before. And I am not happy with all of this between the two of them.
important that there be mutual orders as well. They need to stay away from each other. Part of my concerns and my thought process as I go through this is I'm wary when it comes to the supervision aspect of it, although I'm not going to make a decision on that right now, that if I'm continuing to supervise Taylor's parent time, I'm wary that Dakota may actually try to use that as a way to manipulate and control her.
That's a fair concern.
I think, I'm just not persuaded either that with Taylor's filing, that it was solely due to breaking the cycle of ending the relationship. I mean, I think there's some merit that I'm giving to the declaration of Jesse Draper as well.
Oh boy. That's sealed. But I'm interested if Jesse has given a statement about what she said. But they put on the record earlier that part of the statement from Jesse was that Jesse heard Dakota and Jordan talking about Dakota's plan to take things to the media. And it seems that the court is like, yes, when Dakota goes after Taylor, Taylor gets violent. And my concern is that Taylor does not stop that even when the children are there. But that Dakota is also perpetrating this by trying to ruin her life. And so we have all of this spiraling. And the court said, I don't think that if we just have supervised visitation for Taylor, that Dakota won't weaponize that against Taylor. So the court is concerned. Let me back that up.
That I'm giving to the declaration of Jesse Draper as well. At the same time, I don't think there's an extreme power imbalance between the two of them. I don't think necessarily that Dakota was exercising some kind of necessarily like blackmail, because there's several references where she was inviting him over to her home as well. She shouldn't have been inviting him over. He shouldn't have been going over. And I am just concerned that if I don't order both of them to stay away from each other, that there's going to be some additional problems that aren't contemplated at this, that may not be contemplated. I don't know what to say in terms of what happens when there's mutual protective orders and they find themselves at the same restaurant or at the same bar or whatever the case may be, hopefully not bars at this point. And you're both potentially being subjected to criminal charges if there's a violation of these protective orders.
Stay away from each other. And here's the thing. If you end up in the same place, you both have to leave. You can't say, no, you have to leave. No, you have to leave. And I think the court clocked that accurately, that if there was a protective order only going one way, then you are going to end up with a problem.
I'm hoping that you're not people who just thrive on the drama and the conflict. You've got to put your child first.
I have the same concerns, Your Honor.
The child from this conflict. All right. So my recommendation is going to be mutual protective orders.
Good. That's
I want there to be 100-foot stay away for each of their orders. I'm going to leave the current order in place. I need to think a little bit more about this lifting of supervision. I have mixed feelings about it. On the one hand, I do have some concerns that if Taylor is in a stressful situation, she has not demonstrated an ability to control her emotions. But as I also said, that seems to have only happened when she's been in the same vicinity with Dakota. And like I said, I'm wary about the supervision aspect. The court, I guess I should say this, the court would have regardless of what either party may want, the court would have the ability to lift the supervision at any time. I do think there may be some benefit in waiting to see what's coming out of the assessments that have been ordered from the safety plan. I think there's some benefit there, but I'm also contemplating additional time as well. What I meant to say earlier, the word I was looking for is I felt that Dakota's behavior was a little bit more calculating rather than reactive. All right, so I'm going to take under advisement the issue of parent time. Interestingly, over the next week, I'll be in DC at a domestic violence training while I'll be processing all this.
I mean, that's fair, because judges will be doing a lot of this. And a lot of you in the chat also said calculating. It is the judge's job to see what is going on here clearly and to strive to do that. And the judge has looked at both parties and said, this relationship is a problem. The two of you together are a problem. The two of you need to not be together. And for that reason, there is evidence that Taylor has been physical with Dakota, and there's evidence that Dakota has been physical with Taylor. And the court was crediting both sides on that evidence and also saying, but a lot of the things both of you are saying are also not accurate portrayals. And with the concerns, the court is concerned that only having supervised parenting time for Taylor could be weaponized against her, and that if there weren't mutual protective orders, then it also creates problems. And a lot of you are asking, why 100 feet? 100 feet is fairly standard because it is generally enough to cover the parties not being in the same household, in the same vicinity, in the same area. But also, if they end up at the grocery store at the same time, they can leave and it doesn't necessarily become a violation unless it's proven that somebody is trying to be there at the same time. So it tries to mitigate someone violating a protective order on accident by being at the same Starbucks or whatever, but also keeping people far enough away. I am sure there are reasons that 100 feet was picked whenever it was picked. Sometimes there can be more of that, or more distance, but they also are going to need to be able to at least be in the same parking lot to exchange their child with a third party. So, and yes, the judge will go and do trainings on this because this is the realm that he works in family court.
So I'll have a written recommendation for you by no later, I'm hoping, than the 11th of May at the latest.
Okay. And that's going to be on the parenting.
Any questions about the PO? In terms of the PO?
You want to modify it in any way with parent time?
No, same parent time.
Same parent time for now.
Same parent time as we have up to today, but I'm going to make a recommendation about that parent time on or before May 11th. So I may make changes at that time, and then if that happens, we'll issue a modified protective order that reflects the new parent time order. All right?
And then we'll be here.
That's a good idea.
I didn't hear that.
Review hearing.
Oh, yeah.
You have to, want to do it now? Or do you just want council to file it?
No, I want to put it on a special setting. I'm just wondering how much time do we think we need?
Can we do it earlier in the day though? In
my
You
opinion,
asked for it.
I know. I frankly don't think we're going to need a ton of time. What I want to do is get those
Don't want to
assessments.
put it on my regular protective order calendar where I have 15 other matters.
I think
Sure.
that's a good idea, Your Honor,
Yeah.
not to put it on that calendar.
Depending on how much time you have, I think if we set it for an hour, I think we would be done in an hour. And might be done in less time than that, frankly.
30 days? Are we, yeah. Or do we need more time than that?
Do we want to have the assessments back?
I don't know.
I would like to have the assessments
That's
back.
the
But I'm good
JHL
coming back
talking.
in 30 days
When
and
is
seeing where
when
we're
are you
at.
going in to take your assessment?
We're going to do it ASAP. We have the referral for it.
Let me ask the counsel for the parties.
DCFS hasn't given my client a referral for the assessment yet, but he's been in contact with them and they've been chatting. He's done everything they've asked. So I can make sure we push it up and make sure they get that referral. I would estimate, just based on my knowledge of DCFS cases, Your Honor, and how they go, I think 5 weeks would be the minimum for a review.
Okay.
And I agree with that. And that pushes us out beyond the team meeting that's scheduled for May 27th.
Early June?
So now they're just picking the next date.
And I do want to work with both of you to try to restore this to some sense of normalcy. I really do. I just think right now you two need to stay away from each
Yes.
other, and there needs to be orders that will, result in consequences if you attempt to try to engage.
There should be consequences. It's concerning to me that on a deferral probation, it did not stop there from being future incidents between Taylor and Dakota, because she could have ended up with her deferral probation taken away and ending up with a felony on her record. And that didn't seem to change anything. So I wonder if this will shift that with consequences, or if these consequences aren't necessarily as large as the consequences for her in her pending probation case, which is going to go through to August.
each other, because I still think you have this attraction to each other, physical or otherwise. June 1 at 2 o'clock?
I am available, Your Honor.
That'd work for me.
Okay, Mr. Swinyard?
Would we perhaps be able to do it via WebEx? I expect to be out of town that week.
If you want to make a request for WebEx, I think you have that right. The way I read the rule is that we're supposed to grant those requests unless there's a real compelling reason, like you're going to take somebody into custody.
And I
No,
don't
then
know
we
if we
can-
will cover
We
their
can make the first
check-in.
work. And obviously
what
the court
happens.
is evaluating different scenarios for the
Yeah,
next
and
5 weeks.
And I want to read the case too that Mr. Hall had alluded to, because I think the suggestion there was it's oversimplification to, if I'm making a ruling, I don't want to run afoul of the statute, or excuse me, of the case law. If I'm unduly compartmentalizing, saying everything will be fine as long as she's not around him, right?
That's,
my
That's
case,
the
yes.
argument
You can have
that
my
was
copy
made.
if you'd like.
Okay, all right.
What time on the 1st?
I had
2
2
o'clock.
2 o'clock. Your
2
Honor.
o'clock.
WebEx is permitted.
Mm-hmm. Do you want to do it by WebEx, everybody?
I think it's been
Make
a
it a
long
remote
day
meeting.
and I'd probably want to talk to my client about it, but I love the option.
Okay. All right. So next 10 days or so, I should have the recommendation on parent time. At the very least, I'm inclined to expand parent time. The bigger question for me is, should I be lifting parent time? I think you want to go all the way back to the terms of the agreement. I think I'm kind of more inclined to take baby steps towards getting there. But that's,
think that's
I
fair.
think in a lot, but I don't have really a petition to set aside the stipulation. You were talking about that too.
That's
I don't
fair
know really
too.
what the objective is otherwise, other than what they had stipulated to before. If that motion's filed, that might change, there may be differing objectives there, but where they've already reached an agreement, typically when I'm restricting parent time, I'm working back, trying to work back to where they were before, unless there's ordinarily a petition to modify. Yeah.
That was why I mentioned it,
Yeah,
Your Honor,
yeah.
is that I'm more than happy to mediate and work through something and not just file a motion to set aside.
Please do.
What I don't want to have happen is within the next, few days.
And this is
I'll have to
Dakota's
discuss it.
lawyer talking.
Mr. Sweeney would have just final documents filed and I have to rush one in. That's all.
Okay, all right. All right. Well, I certainly encourage the parties to the extent that they can. Let's check the box for mediation for sure.
Yep.
Because I do want them to keep working on trying to resolve these disputes. Ultimately, it's the hope of the court is that's the place where you get. So you're not dealing with judicial intervention. You're not coming here, giving
That's
up
the
all your
goal.
power and having the court force orders on the two of you that with the assistance of counsel, you're working out these disputes between yourselves.
That's the goal.
That's my hope. I mean, unfortunately, you've been unable to do that thus far.
If we can find a mediator between now and June 1st, will the
Mhm.
court order us into mediation? We can give it a shot there.
Do I need to order it if you're,
You don't need an order
Yeah,
on our
yeah.
part. And I believe our protective orders will have an out for mediation, if I'm not mistaken.
it'll have a
Protective order
box
should-
checked for mediation.
Yeah,
It's
We're
allowed
so just
for
asking
mediation.
if counsel would stipulate to an early.
They are talking about going to mediation and then allowing the protective order to allow the parties to be in the same space together to work on mediation to try to finalize the custody arrangement that has been upended because of this protective order.
Remediation.
Yes.
Okay, all right. If you're both okay with mediating and working on it outside of court, that's something I'm typically always encouraging. I know there's some
Well, now that this is
DV
handled, that
aspects in
might
terms
help.
of, I'm not going to force mediation.
Well, now that the protective orders have been settled, now you might be able to get to mediation on the protective or on the custody time, because I think what they were both fighting for was that the other one gets not granted the protective order. And we heard Dakota's lawyer say that the reason that they wanted that is because they said the court needs to call out who is the abuser here. And there should only be a protective order going one way. And the court was disinclined to do that. And so based on everything the court has seen, the court's like, no, you're both getting protective orders to stay away from each other. And then we will continue to reassess to try to get this back to a place where both of you can parent without every time you are in the same place there being a incident between the two of you.
In a protective order case. Let's put
Most
it that way.
mediations now are online in
Yeah.
separate rooms and we never see each other anyway.
Right,
so-
right.
Yeah.
I mean, if we didn't have Mr. McDonald on the case, this might have been a good one for referral into the new pilot program. But that's presently, that's going to screen it out presently. Okay. All right, we'll come back and have a review hearing then.
All right, so
on
they're having a review
on
hearing.
June 1st at 2:00, but before then, you'll get a recommendation from
I
me
may
in
not
writing
cover the
about
review hearing.
parent time. All right?
I will keep you posted on what the court orders on parent time, either in like a YouTube short or a update on the podcast.
Let me look at it.
But I don't know. Honestly, my hope is that these orders get issued and both of them are able to go and work on whatever they need to work on themselves so that they don't end up back here. That is my hope. And they can both just go away.
It does create, don't want to speak for Mr. Swinyard, but it does create a little bit of a, I guess, chore for attorneys to figure out the parent time schedule week to week.
Indeed, yep.
Week to week?
We've been doing it week to week.
Let me take a look here.
And adding to the difficulty is having to coordinate with supervisors. So hopefully, if and when that's lifted,
Well,
it
the
will simplify.
supervisors are kind of aligned with her, aren't they? Are they making themselves available?
Yes.
Sure, they have their own lives
It's-
too.
You know, it's still a challenge, though.
How many do we have?
2 currently.
2? Did you want to expand that? Is that what we were talking about?
We can attempt to. I mean, we would need to speak with our client and go through the previous system of sending them through Mr. McDonald. We're happy to do that.
I mean, I hate mentioning professional agency, but I believe there's some professional agencies that can at least coordinate. Or we could use, well, I don't know if our family wizard.
The court and the GAL both wanted an agency to help with this. And it seems that that might be appropriate because the court said, look, I would really like to have a report from a neutral third party.
Just yet.
Right. I agree.
That we don't have a third-party intermediary for communicating, or they just did that on their own?
No, we've been doing it through council, which is
Through
not
council.
sustainable.
I don't think that's a role
That's
you want to play
expensive.
necessarily, is it?
Wasn't going to say it, but yes.
Well, I'm okay.
We've been communicating through counsel, and that's not sustainable. Correct.
If the supervisors want, I mean, if you're arranging through parent time, arranging supervised parent time at least, that's going to have to be at a time that's where the supervisor's available. Can the supervisor act as the third party intermediator for making parent time arrangements?
We could, but when we have affidavits filed in cases against my client, you know, it adds to that bias.
It does,
concern. If we
doesn't
could
it?
have someone that's neutral, it'd be excellent.
Parents of each of them?
No,
Are
because
they
his
hostile
parents
towards each other as well?
aren't
The
in.
the 2 sets of grandparents?
I don't think his family's in
believe so.
Utah.
What I can do is I can submit names no later than tomorrow, and maybe council could do the same, submit 2 or 3 names, and I think this is something we'd be able to sort out because you're asking not for a supervisor, but someone to coordinate parent time.
Well,
He's asking for both.
As opposed to the 2 attorney, as
Right.
opposed to the council.
Right, just understand, just make sure I understand the role.
We could submit names as well. We might need until Monday, but
All right.
You're going to be able to work that out without me having to make
I think so.
that decision as well?
Well, one easy way, Your Honor, is to give Mr. McDonald the final call if we have a disagreement of who could do it well.
I would be happy to do that.
Okay, all
right.
right, as long as you're willing. All right, so, I'm sorry, back,
That gives the guardian ad litem the final call on who is going to help being the neutral third party and making sure that the neutral third party is in fact neutral. What the lawyer for Dakota was saying is that if we are going to have affidavits filed and the third party supervisors are her family members, then there is concern that they are not necessarily friendly to him. Though we have seen in Secret Lives of Mormon Wives, there are times when her family, I think, is more friendly to him than to her. I don't know where any of them stand at this point, but that's where they are trying to navigate that you can't have communications with a third party. Like you can't have Dakota's touch point be someone in Taylor's family without the possibility of them getting into an argument. That's not realistic. So you've got to figure out who the neutral third parties are. And the guardian ad litem gets the final say. And I think that's probably a good call.
your question.
I just wanted to know if you wanted me to list somebody's name in there specifically, or if you wanted me to.
Let's just say is mutually agreed, and if there's no agreement, then to be determined by the guardian ad litem. But again, this could all change in the next couple of weeks. I am contemplating lifting supervision. I just want you to know, okay?
Then have a third party to
Okay,
do
anything
the
else from
custody
counsel?
exchanges and be done with it.
Nothing from us, Your Honor.
Okay, wait right here. We'll get the protective orders issued. These are now 3-year orders, just so you're clear. These These orders
Good.
that I'm issuing now are
Good.
3-year orders. They're designed to expire on their own after 3 years. They're not criminal orders. That doesn't result in a criminal record. It does go out on a database though. So if there's an incident that occurs, the police show up, they can run and see that there's a protective order in place, arrest can be made, charges can be filed. First time around, it's a Class A misdemeanor. Subsequent times for violations, third-degree felonies. I'm really intent on trying to keep the two of you away from each other for now. All right? And then later on, as hopefully the dust settles, we can perhaps scale some of that back a bit. All right? I
Good.
just think that's what's best for your child as well. The two of you not be in the same place at the same time with each other.
Yep.
I mean, all of the evidence seems to suggest that's a bad idea.
Agreed. Agreed, Your Honor. 3-year mutual protective orders. I can't hear what any of the lawyers are saying.
Mr. Swinyard?
I mean, Mr. Mortensen's other. Yes.
Oh, yeah.
Joel Kittrell, Kittrell.
What do you need, Joel? To button your jacket? What? Huh?
So we're going to issue the orders. I want, you can flip a coin if you want. One of you leave first, the other remain behind in the courtroom. And until one is able to leave the premises and then the other can
My
go.
client volunteers to go.
The court is trying to navigate who's leaving the courthouse first, because the second they walk out of the courthouse, they need to not be within 100 yards. So somebody's staying in court and somebody's walking out. You're not walking out into the hallway at the same time at all. So who's walking out first?
So we're going to issue the orders. I want, you can flip a coin if you want. One of you leave first, the other remain behind in the courtroom. And until one is able to leave the premises and then the other can
My
go.
client volunteers to go second.
All right. Okay. You do? Okay, okay. Bailiffs have that worked out. All right. Don't leave yet. Don't leave yet. We've got to get you the order.
This Paul's family and council we first last year. And then we'll ask both of you out. Is it okay if I speak right now, Commissioner?
Yes.
So for everybody that's here in the media, I've been advised, program is closed. If there's any interviews that want to be engaged in, we are requiring that you step outside the property and then you can engage in any interview process. But nothing will occur inside the property. Does anybody have questions on that?
Meaning the broader courthouse.
The courthouse itself inside. Once you exit the doors, have any interviews that you'd like to.
Understood.
They're giving the media orders.
And we'll escort you out.
Appreciate that.
All right, I'm just waiting to see if they actually leave court, which it seems that they're going to. But they have to wait for the orders to be typed up. However, I think if I was the lawyers for the party leaving first, oh no, they can't. She has to be served. So
9071.
So they have to be served with the orders, so they can't leave. Because I would say you would just give it to counsel, but you can't. Because they have to physically hand it to each defendant. So we can start to summarize a little bit, but I'm waiting to see if they just give the parties their orders so they can leave. That looks like Taylor's stepdad and mom in court, right behind where she's sitting. We're going to zoom a little bit. I'm just curious to see if they get their orders and then leave. Oh, well, nope. The court turned off the WebEx before they got their orders. Fair enough, because court is technically done. All right. Court is done. It has gotten very late. So, you know, there's not as much light in my office in the evening, but it's fine. We'll fix it in post. So for all of you just tuning in, hi, how are you doing? Oh, we can put on the bad light. Okay. For just a little bit. It's a little bit brighter. It reflects in my glasses some, but it's why we don't stream in the evening. Why? Because I hate having the other light. It's totally after dark. All right. So where are we at the end of the day? At the end of the day, the court ordered mutual protective orders against each party. So they are, I believe the court said 100-yard, might be 100 feet. I think the court said 100-yard stay away orders. We will see it when they are printed up. I can actually look at, because I don't accurately remember what the court said, and I have the temporary protective order, so I'll just pull that up real quick. All of you are saying it's 100 feet. Thank you, law nerds. My back hurts. It's just hard to remember because some of them are yards, some of them are feet. Either way, we have the protective order. We can pull it up. Either way, both parties have been ordered to stay away from the other. That is also going to extend to things like texting, calling, FaceTiming, no communication. And the only communication that they will be allowed through a third party is not third party, baby, I love you text message. Third party, we are exchanging the child at this location. The child is sick. This is what we are doing. We are taking the child to the doctor. Conversations regarding mutual parenting. And the court issued those mutual stay away orders, protective orders, for 3 years. They will automatically expire. Could the parties go back to court and ask for those to be removed down the road? Yes, they could. But what is the court hoping to accomplish? Well, the court actually had quite a lot to say to these parties about the nature of their relationship and did not think much of it. Said that he found that Taylor's behavior was reactive, that Dakota's behavior was calculated, that these parties need to stay away from each other, and basically sat there and said the two of you need to do better for your child, because right now the legacy that you are leaving is a legacy of domestic violence and abuse. And the court looked at all of them and said, or both of them and said, the goal is that you don't need court intervention down the road to parent your child, but you are going to be connected together through your child for the rest of your lives. Essentially, so get it together. So get it together. So what does that mean for the future of Secret Lives of Mormon Wives? I believe I saw reports that Taylor Frankie Paul was stepping away from filming, which I guess means if she's not filming, that Dakota could film, but they can't film together, and they can't have Dakota saying something to Jordan and then Jordan saying something to Taylor or something like that. You cannot have them also talking through third parties. That includes, you couldn't have one of them sitting down and filming and then production saying to them, hey, so-and-so was saying this. How do you respond to that? I don't think they should be filming together. I don't think they should be filming at all. I think both of them need to address what's going on with them, and they need to do so away from the cameras, which I understand is a difficult thing to ask when that is where your job is. However, they're going to need to figure it out. And the court was very clear on that. You're going to need to figure it out. So, 3 years of mutual protective orders. The court is going to figure out parenting time, but is contemplating removing the supervised parenting time. It seems to me, based on the court's statements, and I would love to know what your perception of this was, but it seems to me that the court's concern was what happens when the two of them are in space together, talking to each other in the same location and interacting with each other. That seems to be the biggest concern. I was surprised to hear how much the court gave credence to Jesse, who is also part of the cast of Secret Lives of Mormon Wives, Jesse Draper's affidavit to the court that was filed yesterday. And I was also surprised to hear that Taylor's attorney brought up whether Dakota got Taylor's initials tattooed into his lip, and it came up in court. And then Dakota's lawyer was like, so, Your Honor, funny story. All the dads went out to a tattoo parlor together, and were filming, and they thought it would be, gee shucks, real funny if Dakota filmed getting Taylor's initials tattooed on the inside of his lip. So, Your Honor, really, it's not creepy behavior and it's not like stalking behavior. It's just like dad talk. The lawyer didn't say dad talk. I inserted that myself. So it was an argument I have not seen before in court but Your Honor, we were filming. Like, cameras were up, Your Honor. Cameras were up. Production, it's production things. So we'll see if that makes it to air in whenever season 5 of Secret Lives makes it to air, if it does. But I think the court clocked that these two shouldn't be interacting with each other. And I agree with the court's assessment of all of that. And the court has seen more of the videos taken and of the interactions between the two of them, and came to the conclusion that they need to not be together. They need to stay away from each other. But also, the court does not want to put either party in a position to leverage, well, I have a protective order against you and you don't have one against me. And the court seemed very conscientious of not creating an uneven playing field or an area for one to manipulate the other, and was concerned about that and noted that concern. So where do we go from here? Well, when the parenting order is updated, I'll keep you updated either in the podcast or in shorter form content. When they do a check-in on this, I don't know if we will go to court and check in on that. I was curious to see how the court would navigate the mutual protective orders, and the court navigated it with stay away from each other. We're done. We're done here. We are done. Y'all need to be done with each other. So, what does that mean for The Bachelorette? I don't know. Does that mean The Bachelorette is going to ever air on Hulu? I don't know. Will they just cut everything Taylor and Dakota out of season 5? Maybe. And at what point does production start to look at the fact that these parties should not have been filming together at all beyond that first incident? And at what point, when people's money and the way they make money is directly connected to conflict with each other, at what point does that reach a breaking point? And I think we're definitely seeing it here, but we're seeing lawsuits, as I talked about the last time we talked about this. We're seeing lawsuits elsewhere, not with regard to Hulu, but with regard to Bravo, about where those boundaries are. And I think this case and others are going to start to redefine where those boundaries are on reality TV. And I think we're going to start seeing some of those lines redrawn. Because reality TV used to be, there's never been aspects of reality TV that weren't toxic. I mean, there's definitely some reality TV different than others. This is one of the things I love about competition shows. It's a different thing. But there aren't a lot of boundaries anymore. And how does that get reined back in before people get significantly harmed and it can't be undone? And I think this case and others are going to have to navigate those questions. And we will see. So this is why I love Traitors. I really like Traitors. I really like Traitors. It's a great reality competition show. It's fun. It's light. Yes, people's feelings get hurt because it's basically a game of Among Us where you have to vote somebody out and it is based on deception. But everybody goes into Traitors knowing it's a game. Everybody goes into Traitors understanding it's a game. And I very much enjoy that everybody's on the same footing, where some other reality shows, You see people are like, I'm living my life. And others are like, I'm living a storyline. What are you doing? It's all just for plot line. So with that, I don't know how much we will be following up on this. I'm going to answer a few questions and then I'm going to get going because A, it's been 4 hours. B, my back is done. And C, it's 9 p.m. and we've got a podcast we've got to do this week. It's been a heavy week. And we've got some other court that we're going to have to cover, but we're going to do it over on the podcast. So are you ready? We'll get to questions. Hello, lady. 1231 said, I'm surprised Bravo hasn't had some kind of case like this. It's not been quite like this, but Bravo has a couple lawsuits going on. One with regard to production, promoting alcohol, amongst other things with Liam McSweeney. There's discrimination in there too. And then there's also the Scandival lawsuit alleging revenge pornography and more. I've covered both of those. It's been a minute since we've gone back to the Liam McSweeney case, but the Scandival case is still proceeding forward. So there are a few of them, but they're not necessarily pulling all of production into it. But this one isn't either. It's kind of the background. Production is a background context of everything that's going on here. All right. So Bravo's got a number of lawsuits going on. Some involving production, some not. But it's also, I'm turning off the big light. I'm turning off the bad light, but it's also why Bravo has different production companies that deal with things and not just Bravo dealing with everything. So let's do a few questions and then we are going to get moving. Yeah? Yeah. All right. Let's get to questions, shall we? It's time to chat. All right. We don't have the big light on. To everyone who gifted memberships, thank you. To the members chats, thank you. Kate's the Great said the sense of normalcy has shifted. I think for these two parties, it's going to have to shift even a little bit more. This judge kind of gets toxic relationships and reading the room. Yes, and judges who do family court do a lot of trainings on family court with a lot of different professionals so that they are informed. And that is a lot of what they do in working in family court, which is incredibly difficult work to do. It's good to see you, Lithy, who said, thank you, Miss Lori, my GAL, who helped save my life when I was 15, 16 as I emancipated. And thank you, Evers GAL. When you say my client, it's a reminder of someone carrying GAL's rock. They absolutely do. It is also an emotionally heavy part of being an attorney, but it is something that people can opt into, but it's hard. However, you get to stand up for your client and not worry about what's going on with mom or what's going on with dad, but worrying about what's going on with your client only. Jen asked, how does one become a guardian ad litem? You, in all jurisdictions, I believe, have to be a lawyer, and there are ways that you can apply to become a guardian ad litem, and then there is a process to become a guardian ad litem. So it's going to depend significantly on jurisdiction. But all court systems have guardian ad litems that get appointed to different cases. Music to My Soul said, Emily, it would be so funny if we added code DTF. But it meant difficult to follow. That's funny. That's funny. That's funny. I will take it under advisement. For sure. For sure. Crystal said, can we have a 14 years protective order stay away? I think 3 years will hopefully be enough to get everyone away from one another. I hope that is enough. I hope that's enough. So we'll see. But yeah, the difficult to follow is funny. It would have come up a lot in Banfield, especially as we were going through some of the tech stuff that I was like, I can't do this anymore. We're just fast forwarding this. We're fast forwarding it. Let's see. Ashley, Party of One, said I'm a bit behind on the feed, but as a SLOMW watcher, Secret Lives, I genuinely hope that this is the final straw for Taylor to let go of this relationship and truly move on. I hope that for both of them. I really do hope that for both of them. And again, I worry that when their money is tied up in them being in conflict, it makes it really hard to do that. I think Taylor would still be on the show if she wanted to without Dakota. It is not the same, my perspective, vice versa. She's the reason, I think, that production was like, ooh, what's going on over here? Now, the reason was toxic and messy. So again, toxic and messy. But I think that she would still be on the show and filming and doing other things on social media without him. Him, not so much. And I know that they've tried to pull him into dad talk and been like, no, he's a father of Taylor's kid, and so he should still be here. I don't think he can be. Or both of them just don't film, and that's what it is. So we'll see. But we'll see. I think that and you let me know what you think. If you guys disagree, tell me. I want to hear what you have to say. But I don't think that they would have pulled Bachelorette for anything other than that video coming out. I think that video coming out was a huge part of why it was pulled, because once people saw it, it was over. Henhouse said, if we don't like crumble, can we get any cookies for Banfield? I mean, I'm going to make cookies here for Banfield. I'm going to make big cookies here. And I'm going to make big cookies from Wild Grain. So you can get Wild Grain big cookies, but we're going to get big cookies for sure. You don't have to get crumble cookies. A lot of people don't like crumble cookies. You're welcome to find your big cookies. Brady Lady 2000 said, CPS worker here. Not all jurisdictions require you to be an attorney to be a guardian ad litem. That's good to know. I have a sister in Ohio and a sister in North Carolina who are not attorneys that are guardian ad litem. That's awesome. So, as I say, it varies by jurisdiction. Thank you, Brady Lady, for what you do. Take care of yourself. And it's a good reminder that varies by jurisdiction, but there are a lot of ways to interact with the court system and help attorneys, non-attorneys. So it's good to know. So you, it is one of those things. If you opt in, it is a hard job. Make sure you have support around yourself. Yes. Sunco said we should post cookie pics and tag EDB. Yes. Yes. And we will put up a place in the app to also post cookie pics. You can pick whatever cookies you want. They don't have to be huge. We can just pretend. Banfield can say, but I'm tall. We could all just be like, whatever, my Oreos are gigantic. It's fine. Pick your cookie. Or a biscuit or a muffin or whatever. Cupcake. It's fine. It's cookie adjacent. It's vibes. It's just vibes. So pick your vibe and it's fine. Ashley loves black coffee 16 said, why does it matter to Dakota if she has a protective order versus him? It seemed that the lawyers, and I am basing this off of Dakota's attorney's argument, it seemed that the attorney was arguing that Dakota had done nothing wrong. Everything he did was in self-defense, and therefore he should not be restrained. She should be restrained. So that's what seemed to be the argument. The judge was like, nope. Martha, I had to pull up this comment. Martha Critter said, so that would be CarPlay DM, as we were talking about the text messages coming across the car, which again was an excellent point, because when they were saying she was kicking at the infotainment system, it might have been that a text came across the car. However, don't hit things. Don't break things. Just no. And kicking at the infotainment system in the car is still a problem. Yes. Leslie said, are we still doing Banfield when I don't have any cookies? Banfield is May 8th, if I'm remembering correctly. I'm pretty sure it's May 8th. So we've got, a week? Because it's gonna be May. Yeah, we have a week. We have like a week. Fuck. There is so much going on in the next week. I'm so behind. I have to do things for Dr. B's birthday. Okay, next week's gonna be a busy week. It's a busy week. Tomorrow's a bit, okay. It's May. It's now. May is happening. We're going to go from May the 4th be with you all the way through to Banfield sentencing. It's going to be a busy week. Because actually tomorrow is May. I know. Thank you to everyone who gifted memberships. I'm sorry I didn't pull this up earlier. Trying to parse what everybody was saying in court with the 4-screen is a little bit harder for me. Also, when the back hurts, it is a little bit challenging. I struggle with focus when the back is in pain. So, law nerds, I am working on taking care of the back. We've got a lot to cover next week. I know a lot of you have asked about the updates in the David case. I am going to be doing an update in the David case for the podcast so that you can choose to opt in or opt out, because you definitely should make a choice on that one. It is a lot of information, and I want you to be able to choose to opt in or opt out. Again, with my coverage of every case, I will let you know how in depth we are going, but that one's going to be, it's going to be tough. There is just information in there that is tough, and we are going to cover it without sensationalizing it. However, it is going to be tough information. So I am giving you guys the heads up that we will be covering that. There is more stuff that will be coming up and getting covered. There are other things that we need to cover and we'll be covering next week. So there's a lot to do, but I will be updating on David, and then we will go from there. It is a tremendously busy time. So stay tuned in the Law Nerd app, because that is where I'm going to keep you in the loop about scheduling, because there will be some scheduling ups and downs as we get into May. But I've let you guys know that as we have gone through the last few months, that May is going to be one of the things that is a little bit of when are we streaming? When are we not streaming? So I will keep you in the loop in the app and try to give you guys a heads up so that we know what we're doing. Sometimes those things change closer in time. Sometimes I have a little bit more of a heads up, especially as we get closer to graduation. So, Law Nerds, I was glad to get to stream with you this evening. I know, late hearing. It's been a minute since we've streamed in the evening, but it was nice to have a little change of pace, change of the day. Hopefully, it was a illustrative hearing. Things were learned. We learned a little bit about how much patience it takes for the judge. I'm glad he ordered the protective orders from the bench and didn't say, I will rule on those and you will see them. I'm glad that he was just like, both of you stay away from each other. This is going to be better. And we will get back into some of the other cases that we have been covering next week. Don't worry, I will not forget you. We will get there. Sometimes it just takes a little bit of time. So, music to my soul. Emily, do you have specifics in mind for the cookies you're going to bake? I'm probably going to do, it's going to depend on vibes. Honestly, it's either going to be the ginger snaps or the chocolate chip cookies, but it's going to depend on vibes that day. So it will depend on vibes, as most things do. I mean, it is going to be, how do we feel today? But those are my favorite options. So we'll see. All right, Law Nerds, it's great to see you. Thank you for being here. Hopefully next week I'm just not as wiggly and the back is feeling a little better, but it's been a while since we've streamed at night. So it'll be good. It'll be good. It was fun seeing all of you at the different time in the evening. Utah was just like, hey, we're going to have a late hearing. And we're like, all right, it's fine. It's fine. It's going to be fine. And then we've got a full day coming up. We've got some sentencings coming up. So we've got sentencing for Banfield next Friday, so just about a week. And then the following week, we're going to have the sentencing for Corey Richens. And we've got some other streams to cover documents and appeals and things like that between now and then. So Law Nerds, take care of yourselves. Take care of each other. It's good to see you. And I will see you in the next one. Thank you for being here. Bye, guys. Take care of yourselves. Have a good night. And members, I will see you for a podcast. I will post it in the places when we are getting ready to podcast. Okay. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.